Please, your lord. In item number 11 to 14, in the last occasion, your lordship was granted liberty to make a mention for upgradation, lordship. If I kindly take up this matter, lordship, after motion and order.
It is at 11 only. Yes, we'll do something. Yes.
Deeply obliged. My lord, I beg to mention item number 8. My senior Yasbara met an accident in San Maria area during flood. So he got an head injury. So matter may come after.
As item 8.
Yes.
Lordship, I understand this. He has some difficulty, Lordship, but if Lordship goes through the case record all along after interim order, he is not doing the case, Lordship. Same matter on same point already a matter has been disposed by coordinate bench. So in that case,
We will take it up on Friday.
at least she can arrange someone because she is the petitioner in that case also.
May after 2 weeks.
No, not.
Stay is
We
there,
are
Lord.
having an interim order. There is an objection from the other side.
Because
We are giving you time till Monday,
Lordship.
9. If you are unable to do it, make alternative arrangement. Item 9, item 8, we listed again on 9, as it is submitted that the counsel for the petitioner met with an accident and is unable to appear in court today. Since there is an interim order in favor of the petitioner and the learned CGC appearing for the respondent expressed urgency that the matter should be heard expeditiously, or the interim order ought not to be. In view of such objections raised, this court considers it appropriate to fix the matter on 9.
Much of it.
My pleasure, Lordship. Item number 19, Lordship. Yesterday we have received the additional affidavit, so allow me to fix time to file our response.
Lordship, I'm there appearing on behalf of the petitioners. I have an objection. It may be taken up after a week, Your Lordship. I mean, the matter is fixed in NCLT on 16. They're trying to take it after 16, but we want the matter to be taken up before 16.
Why?
Lordship, because the matter is fixed in NCLT.
So,
Lordship, they're trying to just extend the matter.
we'll have it after 16 if NCLT is hearing the matter. Why should we be in a hurry to pass orders before the NCLT passes orders? If there is no conflict, we'll carry on.
Lordship, then
Let it be after 16,
19.
19. 19. The request made by the counsel for the respondent, Mr. P. Bora. Praying for accommodation, praying for leave to file a reply or a rejoinder, the objection filed by filed with. You have filed what? Affidavit.
Additional.
Additional.
How nicely.
Lordship, we kindly pass over for 10p.
So that voluntary retirement,
Lordship,
time being.
Uh,
Please ask him to hurry. We don't have too many matters.
subject to Lordship, I have got some fixed matter in court 17. It might take long, Lordship. Can it be tomorrow, Lordship?
Tomorrow.
Lordship.
Tomorrow, my senior will be out of station, my lord.
Well, then I will take the chance, Lord. To take a chance, I'll come back.
When is he available? When is he likely to be available?
Now he's on legs in court 5, my lord.
So this is his
Time.
matter.
Yeah,
What can we do?
after some time, my lord. After some time.
After some time is okay, but he's aware that there are 2 matters in 2 different courts. It's for him to arrange his calendar, schedule. You should have the instruction. Passing over a matter for time being affects the continuity of the matters in the board. Please ask him to be present as early as possible. Right?
Sir, here we are leading by a senior advocate Gabby Pathak, my lord.
Hmm?
Senior advocate Gabby Pathak, my lord. Due to some personal difficulties, he could not appear before your lordship today. I pray for the adjournment, my lord.
Yes, Mr. Chaudhary.
Lordship, in this case, one IA I filed Lordship, that is 1694 Lordship,
Yes.
for deletion of name Lordship, because Accountant General has made party Lordship, Accountant General has no role to play Lordship.
Will issue notice here? Will issue notice in the eye? Heard Mr. R.K. Talukdar, counsel for the petitioner, and Mr. D. Chaudhary for
Your objection.
you're for the agriculture, and Mr. R. Mazumdar for the party writ petition. Any objection here?
If we would have been regularized, they would have paid the salary.
No, Lordship, Accountant General for salary Lordship, no role to play Lordship. Para 3 Lordship.
Let me delete it.
This IA has been filed with the petitioner seeking deletion of the name of the accountant from the area of parties in PTC number 5998 of 2024. So, it is submitted by the counsel for the petitioner that the issue in the accompanying this petition is with regard to the confirmation, regularization of the writ petitioners in their services as they're serving as
And they are serving as assistant agricultural officers. Agriculture development officer.
agricultural development officer under the agriculture. Their services are extended by the government from time to time. So it is submitted by Mr. Talukdar that the accountant general has no role in respect of regularization or payment of salary. The petitioner. The petitioners are in service. Petitioners are in service and they may be retained or may not be retained in service, but there is no claim by the petitioner specifically against the accountant general. It is not a matter of pension. Accordingly, this IA has been filed seeking deletion of their names as they are not a necessary party at all. Whereas Mr. Mazumdar on the other end submits that had the petitioners been regularized, perhaps their presence as a party respondent would have been necessary, but as of now, there is no specific claim against the accountant general. Therefore, he does not object to the prayer made. So, similar, no objection is expressed by Mr. B. Chaudhary, counsel for the respondent. Accordingly, the I stands allowed. Names of the applicant, accountant general. Where is the there it is respondent number?
Respondent number Lordship, 4 Lordship.
There it is respondent number 4 stands deleted. I is therefore allowed. Writ petitioner will file amended post title into the registry within 1 week. Or within the course of this week. File it within the course of this week. Yeah. The writ petition you write, you have the order passed in IA number 20. IA number 20. The name of the accountant general is deleted as respondent number 4 from the array of parties. The petitioner will file amended post title to the effect before the registry within the course of this week. It will be listed again.
Around 17th, madam.
17. Why 17?
I am led by Senator KP Pathak and the respondents are also comfortable with 17 if it's convenient.
Right, 17 June. The D or I pays for respondent number 17. Itu এক নম্বর domain. No, your counterpart is not here. Please inform Mr. R.K. Deshmukh. Yep, yep.
The petitioner was required to file his application for voluntary retirement.
Hmm.
He had filed the application. Apparently, my lord, he had again given a date for 31st of July 2026, whereas the application can be filed only within 3 months. That difficulty remains.
Who has given a date?
My lord, the petitioner, he was transferred. So we moved this honorable court saying that we'd like to go for voluntary retirement. And that needs to be considered before we are transferred out from this place. This honorable court had given us an opportunity, my lord, on 13/5/2025.
Yes.
Where, my lord, we were required to file in that voluntary application if so desired. My lord, thereafter, we had filed an application. Apparently, my lord, he again files it for July 2026, whereas, my lord, per the instructions, it has to be within a period of 3 months. That difficulty remains. And that application apparently has been returned to him saying that he needed to be within 3 months.
Then
There is a difficulty, Lordship. In any case, Lordship, his problem is there are some medical problems
Issues are there.
out there. But the battalion to which he has been transferred, Lordship, that is in Delhi,
best of medical.
best of medical, Lordship.
So
Thing boils down to that if he has to retire from Delhi, the entire pensionary papers are done at Delhi, only unconnected.
he has joined the service. So
That is
his
all.
date of entry and his date of exit, like all service holders are known to the authority as well as the income tax.
True, man.
From where and how he will exit, that is not known. But the fact that he will exit, and he also has information that there is a strong possibility he will not exit from the station that he had entered. So if these are accepted, then how does it matter whether he is pensioned in Delhi will be transferred, not transferred?
May I pay this way, my lord, Lordship disposes of the petition with an observation that if he files a voluntary retirement application which they can consider, then they would duly consider it, whether he moves or not, my lord.
No restraint is
That
required. in that.
different cause of action, Lordship.
No restraint is required.
No, we are not to retain him back till the disposal or till the disposal of the representation, but at least they'll have a consideration in case he needs to move.
He has not filed. We have given him.
No, my lord, it was filed, my lord, but it has been returned back to him.
No, he is filed with effect. for
Yes, that is what I say, my lord.
26. This is contrary to the guidelines of the route.
I tried to reason with him.
So he doesn't reason.
Therefore, my lord, all
He
I'm,
remain where he is. What is the difficulty? He doesn't want the relief.
he wants the relief, my lord, but he needed
He
a service.
wants the
Year
relief.
service.
He must fit within the parameters prescribed.
That is what, my lord. If lordship would only observe that he files it within the parameters prescribed, otherwise that liberty would go, my lord.
No, it is here.
Only that part lordship observes that if he files it within the parameters of the respondents, they would consider, otherwise he goes. He doesn't file it, he goes. I cannot reason with the person who wants a year service. That is also difficult with me. Perhaps the third time he'll try to file it all with 1 year left.
We are closing it then. It does indicate that if he wants, he can file it as per the standing, what is that?
Or he can further parameters for voluntary retirement. Otherwise, it is within a year from the date of his actual retirement.
But we are not extending the interim order. How can? How can we extend the interim order?
Perhaps the joining time can be from the disposal of the petition.
That we can,
That can be because there was an interim protection.
so that we can,
That can be.
how much time you require? 25.
The usual joining time, whatever he gets. I think it is a period of 10 days that he gets usually.
Our third learned counsel for the Mr. The petitioner is before this court putting challenge the transfer order dated 31/3/2025 issued by the respondent authority. The petitioner was transferred to his new place of posting. It is the case of the petitioner before the court that he had submitted an application seeking voluntary retirement. And as per the what he calls standing order number 04/2022, which governs the transfer and posting of officers up to the rank of deputy commander. A person ought not to be transferred. At that, where is that standing order and that particular clause?
Transfer policy is at Annexure 7, page 30.
No, that particular
Page 34, madam.
voluntary retirement.
Terminal posting, madam.
As per the standing order, officers, officials / personnel who are due to retire within 2 years, we reckon from the cutoff date may be considered for terminal posting to his place of preference or to a nearby place / station / region covered by overnight journey by train, provided he is not posted there in the previous tenure. So the Learned Counsel submits that he had already filed an application seeking voluntary retirement. And therefore, in terms of standing order 7 within bracket 6, he ought to have been given his transferred to a place of posting or a nearby place instead of the present place of posting where it's not to be done. So, this court permitted the respondent to complete the instruction. So, he turned a TSDI upon instructions of the earlier date, informed that he had sought for voluntary retirement with effect from December 26.
Madam.
December 26.
Initially, now from July. First he sought it from December, now he has filed another application
And
from July.
subsequently filed another application seeking voluntary retirement with effect from July 2020. Stop. He submits that the standing order 7/4 does not cover such cases and does not specifically refer to cases or cases where applications are filed for voluntary retirement. In any view of the matter, the petitioner was permitted to file an application before the authorities giving him liberty to indicate that was permitted to file an application for voluntary retirement without further delay. Pursuant to this order dated 28/5/2025 passed by this court, the matter is listed today, and counsel for the petitioner submits that he has, in view of the leave granted by this court, he has filed the application seeking voluntary retirement with effect from July 2026,
31/7.
31/7/2026. So, having heard the counsel for the parties and upon careful perusal of the standing order as well as the requirements made in the writ petition, it seems that the standing orders do not specifically cover cases where members of the boards apply for voluntary retirement. So, that apart, voluntary retirement is an offer made by the incumbent which has to be accepted by the authorities concerned. And it is only after that that the process for exit of the incumbent on voluntary retirement is given effect. So, in the facts of the present case, the petitioner is not seeking voluntary retirement within the next 6 months. He has filed in an application seeking voluntary retirement with effect from December 2026, the first instance, and subsequently another application seeking voluntary retirement with effect from July 2026, 31/7 July. So, even assuming that the authorities proceed to proceed to process his request, the same is likely to take some time, and that cannot be a ground to suspend the routine transfer order led to in a discipline course by the, what is this, PSF,
CRS.
CRPF, which is concerned with the law and order and security issues of the country. So, the petitioner also claims to be suffering from what ground, what disease?
Diabetes.
Diabetes. Only diabetes.
Other connected,
That's not a disease.
they compulsorily retire persons based on the disease.
That's not a disease. It's a condition. It leads to some other disease.
No, the only, if Lordship has page 23, it is only because of diabetes that I'm placed at low medical category of P3.
Lordship will see page 26. These are the medicines prescribed. Some of them I also take. Metformin.
If he is fit, then he comes to fit.
No, I'm from
Even.
2006. I'm diabetic from
Then he
2006.
becomes physically fit.
It is submitted that the petitioner is suffering from diabetes, and because of which he has been placed in low medical category. And therefore, this is also a ground for the petitioner seeking voluntary retirement with effect from 31st July 2026. Stop. Vera. It is no longer res integra that transfer is the condition of service, more particularly in cases of discipline forces. So there is a complete standing, there is a detailed standing order which governs transfer and posting. It governs the transfer policy of Group A officers up to the rank of deputy commander. So petitioner is what? Deputy commander?
No, the constable.
The constable, and is therefore governed by the state policy. In terms of the policy, there is no restraint on transfer in respect of person who have filed applications seeking voluntary retirement which are yet to be accepted and processed by the department. So, under such circumstances, this court is not inclined to interfere with the transfer order, which is impugned in the present writ petition. So, the petitioner, from the pleadings, it is seen that the petitioner is being transferred to Delhi. Needless to say that his station in Delhi will have ample avenues for medical treatment in the event the petitioner desires to undergo such treatment. So, needless to say that the closure of the writ petition will not be considered as a bar for the petitioner to file any further applications for voluntary retirement or reconsideration of the orders of transfer if permitted in law and if the authorities so desire to reconsider it. So, considering all of the above, writ petition stands closed. Interim orders passed, case stands vacated. It is made clear that the petitioner will be entitled to the extended time for joining as per the rules with effect from the date of closure of the writ petition, which is today's date. Response.
Obligation.
My lord, in this matter, I have received few instructions, my lord. I need to bring you some better paragraph.
Mr. Hardcore, counsel appearing for the respondent.
এই কিতা হল
Submitted that
মানে দিন হয়েছিল
he has come in, he would like to bring it on record. He seeks liberty to file additional affidavit. There is dictated to by the counsel for the petitioner. Mr. D. Sharia appears for the accountant general.
Lord, respondent to
Let the matter be listed after
10 days only. In 10 days.
2 weeks.
Date may be even, anything.
But
All right.
Mr. Das will take up your matter in seriatim. There are not too many matters.
Lordship, no issue. Well, so far this matter is concerned, I was ready otherwise, but then my lord, the record of the disciplinary proceeding hasn't come yet. So let it be taken up after 1 week, my lord. Even my lord, in this case, possibly, my lord, the record may not be necessary. It's very on a short point.
It's up to you. If you say records are necessary, we'll wait
No,
for the record.
record line.
If you say records are not necessary,
But to my mind, it without
what
that,
are you challenging? This is a dismissal order.
Yes, no. Initially, charge sheet was issued and that 2010, and after proceedings, removal from service penalty imposed. Then the petitioner approached before this honorable court. Honorable court.
They did not file an appeal.
Yes, everything done. It is a fourth round of litigation. Well, the entire penalty was quashed, and they approached the division bench. Division bench did not disturb the findings. Otherwise, the division bench can find that the non-furnishing, non-following the procedure of disagreement note. So remanded the matter back to proceed from that stage inquiry. And they also passed an order that the inquiry will be held subsequently. No inquiry was conducted. And again, they passed the imposed removal order. So he filed an appeal. After appeal, they have disposed of the appeal with some finding, and he has been imposed the penalty. His initial stage, that 1991, he joined as an assistant. That penalty has been imposed. So in the findings, my lord, this I will show, the inquiry officer has held that the two charges not proved, delay deposition of the premium amount has been proved, and in the findings, the appellate authority has held that all the charges have been proved. These are without evidence, and also some findings has been issued which are not in the charge and not in the finding.
Well, the position is not that at all. What happened, my lord, in short, I am telling your lordship.
Oh.
He was the cashier of the company. Now, he used to take premium. The cash premium, my lord, he has utilized for his own purpose for long 4 to 5 months. Then we have issued the charge sheet. He has admitted that he has utilized this money without the consent of anybody, utilized for 4 5 months in order to.
there is a-
Please
there is-
let me say, you will have your turn, have your not okay. Now, this is the situation, my lord. Then, my lord, disciplinary proceeding was on. Then we found that he has utilized this money for his own purpose. He has admitted that. Therefore, my lord, punishment of removal was given. Then he came in appeal. Appellate court has said, since, my lord, there was an inquiry officer finding was the disciplinary authority has said that they will go for further inquiry in regard to that. Now, they did not issue notice to the petitioner. Therefore, the appellate authority has said, the appellate forum has said that you go for disciplinary authority, and disciplinary authority from on that date, they will start a de novo inquiry. Inquiry was made, he was found guilty, he was removed once again. Then he filed an representation before the highest authority, is the CMD. So CMD has said, in order to have some mercy on him, he said, you see the matter, and ultimately he was reinstated with giving some punishment. Now what happened, my lord, your lordship, kindly see the last letter at page 160, 61.
That means something from the charge sheet.
Charge sheet, these are all boiled down to,
I mean, if the hearing
my lord,
is-
then
this
let
way,
him
my lord,
start.
hearing is conducted.
Let him start, then I will reply.
My lord, I will
Your
start
lordship,
from the
kindly
charge
see
sheet.
page 161.
And findings of this honorable.
Please, I am submitting. Why you are coming in between? It's not TV show that going on here. Your lordship, kindly see 161.
Yes.
Paragraph 8, my lord. Hence, on overall consideration of all the above facts and circumstances of the case, the inescapable conclusion that emerges is that the charge level against the appellant are proved based on the principle of preponderance of probability in the inquiry held in accordance with rules and the principles of natural justice. Based on the above conclusion, I am unable to agree to the request of Mr. Pradeep Kumar Hazarika for setting aside the charge memorandum dated so and so. Rejection of representation for delay in submission by the delinquent employee being challenged at Honorable High Court, Guwahati, case number so and so, and as per order of the Honorable High Court, to consider the appeal on condonation of delay is considered. Further, on thorough review of the representation, the earlier order of removal from the services of the company, which shall not be disqualification for future employment, is amended as setting the delinquent employee to the initial basic pay as assistant, subject to recovery of any loss for claims from the date premium was collected and up to the date of recovery to be treated as personal recovery from the employee. Now, this is the line is very important. The period from the date of his suspension to the date of removal of his service as such to be treated as continuation of service. Because of committing this mistake, my lord, we issued an addendum which your lordship will find at page 162. Further to our at page 162, my lord.
Yeah. So tell us, what is the finding of the division bench?
Division, I am taking to your lordship. Your lordship will see at page
Page 101.
109, my lord.
189.
109, paragraph 12. In view of the foregoing discussions, this appeal stands partly allowed by affirming the learned single judge's order in setting aside the order of penalty dated 15/6/2012, but by modifying, altering the directions of the learned single judge to the extent that upon reinstatement of the respondent, the appellant company would be at liberty to proceed with the inquiry by placing him under suspension and continuing the inquiry from the stage of furnishing him with the tentative reasons of disagreement with the findings of the inquiry officer in respect of charge number 1 and 3, by giving him opportunity to represent, to rebut, and by affording all opportunity of hearing. It is also made clear that consequential benefits due to reinstatement be left to be decided by the appellant company depending upon the final outcome of the proceeding. To reiterate, the reinstatement would be only for the purpose holding the fresh inquiry from the stage of furnishing the tentative reasons for disagreement and no more. Now, this is the order. Accordingly, my lord, further inquiry was made. He was found guilty. He was removed. Then your
So
lordship will
ultimately,
find,
division bench allowed the finding, upheld the findings of the single bench
my lord,
in respect of de novo, I mean, fresh inquiry,
yes, yes,
fresh inquiry. And reinstatement.
reinstatement. But then, my lord, your lordship kindly see the language. To reiterate, the reinstatement would be only for the purpose of holding the fresh inquiry from the stage of furnishing the tentative reasons for disagreement and no more. Now, the chance was given to us, go for further inquiry. Further inquiry was held, he was found guilty, he was removed. Now,
Were there any findings, why the single judges set aside the
yes, yes, that will be there.
inquiry proceedings and findings?
My lord, your lordship may, let us see. Let me read the judgment, my lord, from
Page 97, para 27.
my lord, your lordship kindly come to page 102.
You can start from para 24.
There are 24 of judgment, my lord.
Of the single bench judgment,
Single,
page
yes,
95.
my lord.
Is it the same inquiry officer or different?
No, no, no. Inquiry officer was different. Paragraph 24. Thus, from the above communication of the disciplinary authority, two things are noticeable. Firstly, disciplinary authority held that contrary to the record of the inquiry officer, recorded finding of partially proved in respect of charge number 1 and 3. Secondly, disciplinary authority did not agree with such finding of the inquiry officer and taking the view that all the three charges against the petitioner stood proved, gave him a second opportunity to explain his position vis-a-vis the charges. It is true that disciplinary authority is not bound by the report of the inquiry officer. Finding of the inquiry officer is not final. It is only his view. Ultimate decision is that of the disciplinary authority. However, when the disciplinary authority delegates conduct of inquiry into the charges against the delinquent to a third person, that is the inquiry officer, he may either agree with the findings of the inquiry officer or he may disagree with the findings of the inquiry officer. In this case, we are concerned with the second scenario. Question for consideration is as to what is the procedure to be followed when the disciplinary authority does not agree to disagree with the findings of the inquiry officer and proposes to impose penalty by holding the delinquent guilty. This question was gone into by the Honorable Supreme Court in so and so, so and so. In the said case, after considering various decisions of the appeals court, held that whenever the disciplinary authority disagrees with the inquiry authority on any article of charge, then before it records its own findings on such charge, it must record its reason for such disagreement and give the delinquent officer an opportunity to represent before it if records its findings. The report of the inquiry officer will have to be furnished to the delinquent who may thereafter submit his response. It is after considering all the materials, including the record of inquiry report, and the response of the delinquent, that the disciplinary authority should take its final decision. In view taken by the Apex Court in Kunja Bihari so and so, approved and followed in subsequent decision of the Apex Court, where it has been held that non-furnishing of the copy of the recorded reasons for disagreement from the inquiry report itself causes prejudice to the delinquent and would be per se violative of the principles of natural justice. In that case, the decision of the single bench of the High Court quashing the dismissal order on the above ground, which was overturned by the division bench of the High Court, was restored. A single bench of this court in so and so held that since the disciplinary authority disagreed with the inquiry finding, he was duty bound to record reasons for his disagreement. But in that case, while differing with the inquiry finding, the disciplinary authority failed to disclose any reason holding that an illegal procedure was followed, which vitiated the major penalty of reduction in the pay scale imposed on so and so. Rule 26(2) of the 2003 rules also provides that if the competent authority disagrees with the findings of the inquiry authority on any article of charge, it shall record its reason for such disagreement and records its own findings on such charge. If the evidence on record is sufficient for the purpose, therefore, even this rule requires recording of reasons by the competent authority in case of disagreement with the findings of the inquiry officer. Now, following the Supreme Court decision in SP Malhotra Supra, copy of the recorded reasons for disagreement from the inquiry report would have to be furnished to the delinquent to enable him to submit his response, which should be considered by the competent authority before taking final decisions. Thus, from the above, it is quite evident that in case the disciplinary authority disagrees with the findings of the inquiry officer, that a particular charge against the delinquent has not been proved, he has to record his reasons for such disagreement, which has to be communicated to the delinquent to enable him to make a representation to meet the reasons for such disagreement. Failure to follow this procedure would be per se violative of the principles of natural justice and would cause prejudice to the delinquent. It would be an illegal procedure and would vitiate the decision-making process. Having noted the legal position as discussed above, the procedure adopted by the disciplinary authority may be examined. From the communication dated so and so, it is quite evident the disciplinary authority did not record its reasons for disagreeing with the findings of the inquiry officer as regards charge number 1 and 3, which are the main charges. These fundamental lapses by the disciplinary authority has been further compounded by wrong recording the findings of the inquiry officer as regards charge number 1 and 3 by the disciplinary authority. The inquiry officer gave the clear finding that charges 1 and 3 are not proved. This has been misread and misrecorded by the disciplinary authority as partially proved. Therefore, such misrecording by the disciplinary authority of the finding of the inquiry officer upgrading regarding charge number 1 and 3 is contrary to the record and is thus perverse. From the above, it is quite evident that the disciplinary authority followed an illegal procedure which has completely vitiated the decision-making process. Such illegality is further compounded by misrecording of the findings of the inquiry officer in respect of charge number 1 and 3. Therefore, the penalty imposed which flowed from such a flawed procedure cannot be sustained and is liable to be interfered with. At this stage, it may be mentioned that decisions relied upon by so-and-so have been duly considered, but those decisions are not on the above issue and therefore could not be attracted to the facts and circumstances of this case. Before concluding, there is one more aspect which needs to be mentioned. Petitioner was charged with misappropriation of premium money as per charge number 1 and 3, which was held to be not proved by the inquiry officer. On the basis of the materials in the inquiry, including the evidence adduced by the witnesses on behalf of the disciplinary authority, that is PW1 and 2, the inquiry officer gave the categorical finding that there was no misappropriation of premium money, but the late submission of the same. The major amount by just 2-3 days. At this stage, it may be pointed out that the above two witnesses were introduced during the inquiry through the list of witnesses in support of charges framed against the petitioner annexed to the charge sheet as annexed D. It was remarked, Neil, this was also a procedural impropriety. Discarding the report of the inquiry officer, disciplinary authority held the charge of misappropriation to be proved. When same has been put to challenge by the petitioner before this court, by way of the present writ petition, stand taken by the respondent in the counter affidavit is that petitioner was guilty of temporary misappropriation. But this was not the charge framed against the petitioner. It is settled proposition that the charge framed against the delinquent should be specific. Even Rule 25(3) of the 2003 rule says that the competent authority is required to frame definite charges in a case proposing major penalty. As noticed above, petitioner was charged with misappropriation and not temporary misappropriation. Be that as it may, now ultimately, my lord, accordingly, and in view of the above, impugn order dated so and so set aside and quashed. Against that, we came before the appellate forum, and the appellate forum has is interfered with this. My lord, the lordship has seen in para 109. The finding of the appellate forum is that in paragraph 12,
Where is the subsequent inquiry?
subsequent inquiry, your lordship will find. If your lordship look at page 154, my lord. This will make the entire picture clear.
This is the disposal of the order.
Yes.
Appellate order.
Your lordship will find the order was passed by this honorable court at page 152. In view of that, order was passed. At page 1552.
No, 152 is a subsequent writ petition.
Yes, my lord, what happened? They filed an application saying that for disposal of the appeal.
That's right.
And
No,
this honorable court passed an order.
No. First, there was a writ petition
Yes.
challenging the first findings of the
Yes.
disciplinary authority.
Now, your lordship is saying that after the writ appellate court order, that the inquiry proceeding of that particular thing. My lord, that of course, if your lordship want to look at, I'll have to bring the record.
Because that is the core issue now.
Now, core issue is, my lord, issue is only this, as I wanted to take your lordship to that. What happened, my lord? Once again, if your lordship look for a file 161 at page paragraph 9. In fact, my
161.
lord, 161, yes. My lord, if your lordship look at those evidences, your lordship will find this is only a case where removal is the appropriate punishment, removal and or dismissal. Because he has swallowed the money, the public money, and utilized it for 5 months. For his own purpose, he has admitted that. Now, accordingly, removal was passed only because an order was passed by this honorable court to consider his appeal. And then the CMD, what he did, he passed this order saying that.
Let us understand the fact. First, there was an inquiry.
Yes.
Inquiry officer said 1 and 3 partly proof or something like that.
Yes.
Disciplinary authority disagreed, saying all 3 proof.
Right.
And some penalty order was, he filed it, came before the court, court said fresh inquiry.
Yes.
Reinstated.
Then we have
Then
gone
come
for
to the appellate authority, the state, with some modification.
yes.
Then what?
My lord, after the inquiry was held, then he was
After reappeal, what happened?
yes. After the fresh inquiry was held, he was removed once again.
Where is the fresh inquiry?
Yes, that if your lordship like to see that, then that
Is
will
it
I'll
under
have to-
challenge?
My lord, I will just kindly come to
Is
one
the
point.
fresh inquiry report under challenge?
No need for report. I may kindly, my lord, look into page 120.
Therefore, what I wanted to say
Page
at this
120.
stage, my lord, if your lordship look to this
Page
161,
Page 120.
what they want now. My lord, para 9, your lordship kindly see.
No. We'll look into whatever you said, but
Yes.
first Kindly answer
Yes.
the queries by the court.
Page 120.
120. What is there?
128.
128.
20.
What is there?
That is the order of the disciplinary.
Where is the inquiry report?
My lord, that is what disciplinary case, there will be inquiry. No inquiry is done. That is was record. Produce the record what inquiry was done.
Let's produce
Disciplinary
our
case
record.
consciously pass the order.
128 is
This is order of disciplinary. The appellant company would be at liberty to proceed with the inquiry by placing him under and continuing the inquiry from the state of furnishing him with the tentative reasons of with the findings of the inquiry. In view of the specific direction of the inquiry was wrongly issued and the same stance withdrawn. They have passed another order of removal that again withdrawn without any inquiry. Now the findings.
No, how he is saying that I don't know. No, I'll
Record
produce
with-
that record.
Only record with whether inquiry is done. Only record.
Let's see whether whatever he is saying, whether correct or not. So for my instruction, inquiry was there and he was removed. Is 161 make the thing clear, man?
what was the finding of the appellate court? Page 109.
In view of the foregoing discussions, his appeal stands partly allowed by affirming the learned single judge's order in setting aside the order of penalty dated so and so, but by modifying, altering the directions of the learned.
So the direction of the single judge in setting aside the penalty was upheld.
Yes.
All right. Then
The order of penalty dated so and so, but by modifying, altering the directions of the learned single judge to the extent that upon reinstatement of the respondent, the appellant company would be at liberty to proceed with the inquiry by placing him under suspension and continuing the inquiry from the stage of furnishing him with the tentative reasons of disagreement with the findings of the inquiry officer in respect of charge number 1 and 3 by giving him opportunity to represent, to revert, and by affording all opportunity of hearing. It is also made clear that consequential benefits due to reinstatement be left to be decided by the appellant company, depending upon the final outcome of the proceeding. To reiterate, the reinstatement would be only for the purpose of holding the fresh inquiry from the stage of furnishing the tentative reasons for disagreement and no more. Now, the reinstatement was not just for reinstatement, it is for the purpose of completion of the inquiry. Because here your lordship ultimately will find the charges,
Therefore, no second inquiry is called for.
my lord, because here your lordship kindly see, with the liberty to proceed with the inquiry by placing him under suspension and continuing the inquiry from the stage of furnishing him with the tentative reasons of disagreement with the findings of the inquiry officer in respect of charge number 1 and 3 by giving him opportunity. So this liberty was given to us that you can go for a fresh inquiry by giving the reasons. Now, this was, my lord, and the reinstatement was merely for the purpose of the inquiry. That is the finding, my lord. And, my lord, that your lordship may see the order passed by. That's why repeatedly, my lord, I was requesting your lordship to page 161 at paragraph 9, my lord. Better, my lord, if I read the entire order, which is at page 154.
No, you first point out that 169. Yes. Earlier
One-
part will give a history which we don't require. Let's find out
161, yes.
What is the conclusion?
As stated above, the Honorable High Court by order dated 30/11/2021 has disposed of the aforesaid petition, directed the appellate authority to decide the petitioner's appeal on merits within a period of 3 months. The relevant portion of the aforesaid order has been already reproduced in the beginning of this order and is not reproduced here for the sake of brevity. I have carefully examined the submission in the appeal and recorded my response thereto as stated above. I noticed that there is adequate reasons to hold the charges proved based on the principle of preponderance of probability that Sri Pradeep Kumar Hajarika has violated the company's norm by not depositing the premium money on time, and thereby the company has suffered loss of interest income on the premium as well as non-compliance of section 64 BB of the Insurance Act. However, in view of the facts of the matter, as there is no direct financial loss of premium income to the company, so the penalty imposed by the disciplinary authority is reviewed in the interest of justice. This is, my lord, while considering his appeal. When this honorable court sent the matter to the appellate authority. Now, hence, on overall consideration of all the above facts and circumstances of the case, the inescapable conclusion that emerges is that the charge level against the appellant are proved based on the principles of preponderance of probability in the inquiry held in accordance with the rules and the principles of natural justice. Based on the above conclusion, I am unable to agree to the request of Mr. Pradeep Kumar Hajarika for setting aside the charge memorandum dated so and so. The charges are all remain, my lord. Misconduct has not been obliterated. It is just a sympathy given by the appellate authority. It was not necessary.
You are challenging this order
Yes.
before this court.
It's
Yes,
challenging
my
this
lord,
order.
in my page 30, para 30 of my writ petition, I have categorically stated as directed by the Honorable Division Bench. No further inquiry was conducted. They are not
No, division bench did not direct further inquiry. That
in
is why I'm asking.
no stated after providing opportunity of hearing, and they
That-
have
That disagreement note was given to you.
disagreement. I have
And you filed
represented.
a reply.
I have represented. That is what I am. My humble submission is there. How the charges 1 and 3. Honorable single judge has held that charge 1 and 3, that is the misappropriation, not proved by the inquiry officer. And how they now come to the findings as misappropriation proof?
That is the disagreement note.
That is what. That is ultimate conclusion at page 161, holding that entire 1 and 3 also proved. Where is the misappropriation proof? 161 holding that misappropriation proof. And Honorable single judge in earlier line of litigation has correctly held that the delay, there was some delay, major portion on 2-3D delay. And also procedural violation, my lord, observed and findings given that some outsider has been taken in the proceeding without notice. This has not been discharged by the Honorable Division Bench. So, my lord, the 1 and 3, how they have 1 and 3 proof? Misappropriation, they are still holding that misappropriation proof. An entire 161 findings based on misappropriation.
What is charge 2?
Charge to the delay payment, delay deposition. Delay deposition, my lord, that I have stated here, I have deposited and I have of my own, I have deposited in my representation, I have
You're
stated.
not doing a favor. You're supposed to deposit it.
Yes, yes, delay deposit, I have
But-
deposited, delay. I have not shocked, no, nothing. I have on my own deposited, but
No,
delay.
you have no option but to deposit.
Yes, yes,
That
I
is
have,
your job.
that is where I delay, I deposited.
But you deposited after
Delay,
delay.
Delay, that has been,
Therefore, he doesn't give you any handle to say that finally you deposit.
no, my lord. My humble submission is that you demand, no demand was that I delay.
No demand is necessary.
So that is what my honorable single judge in earlier round of litigation has held. The delay, maximum portion delay 2-3 days. Now the penalty has been imposed based on charge 1 and 3.
No, but earlier you were terminated.
Here, holding that all the charges proved. Now still their stand is that all the charges are. 161 my lord pays, all the charges are.
My lord, I don't know why he is arguing all that. It is not necessary at all. He is lucky that the authority has reinstated him. Otherwise, it's a case of dismissal. Your lordship kindly see, he has admitted that position. Just 3 lines I will read.
That all these facts are
It is not
dispute.
necessary,
There
my
is no
lord.
dispute. But single judge held that the finding of the disciplinary authority that there was temporary misappropriation bad because that was not a specific charge.
My lord, with all respect, my lord, I will say, there is no concept of temporary, permanent. It's not like misappropriation is if it is said to be temporary.
No,
My lord,
this is the finding
finding, my lord,
against which you went in appeal.
yes.
Appellate authority did not disturb that finding.
Appellate authority did not upheld that position also, my lord.
No, did not.
I am not going much on that, but there are
You
Supreme
have
Court.
to, because ultimately the question would be whether the conclusions arrived at by the inquiry officer
Yes.
are to be the basis of the subsequent punishment or not.
My lord, if you're,
Was there any interference in that finding? Division bench did not interfere,
division bench has,
rather upheld the setting aside of the penalty.
my lord, to that aspect, I have my reservation, my lord, because this is because their last 2 lines,
You may have reservations, but this is the division bench order, so it has to be binding.
division bench order say to reinstate to reiterate the reinstatement would be only for the purpose of holding the fresh inquiry from the stage of furnishing the tentative reasons of disagreement and no more. Therefore, my lord, when we have found that he is really guilty and the single judge's order that temporary misappropriation is not the charge, my lord, the Supreme Court has said number of occasions the misappropriation.
Your argument that should have been before the division bench.
My lord, we have
You may have,
argued that
the division bench did not clarify that.
we have placed those
Rather, the
decisions.
division bench has interfered, upheld the interference.
Now, ultimately,
If
my lord,
the division bench has to upheld the interference, it must be necessarily concluded that the division bench has also upheld the findings and conclusions of the single bench.
no, my lord, then I think I should bring my record because he was removed and then they have challenged by filing a writ petition. By filing a writ petition, this honorable court said that the appellate authority will see that position.
The question is, once there is a finding and judicial proceeding,
Yes.
it has to be binding. There is a binding effect, not only on the parties before the court, but on coordinate benches.
No, all right, my lord, with all respect, I only say.
Unless it is reviewed or interpreted with by
But I think the division bench judgment, my lord, I'll read once again. In view of the foregoing discussion, this appeal stands partly allowed by affirming the learned single judge's order in setting aside the order of penalty dated so and so, but by modifying, altering the directions of the learned single judge to the extent that upon reinstatement of the respondent, the appellant company would be at liberty to proceed with the inquiry by placing him under suspension and continuing the inquiry from the stage of furnishing him with the tentative reasons of disagreement with the findings of the inquiry officer in respect of charge number 1 and 3 by giving him opportunity to represent, to reward, and by affording all opportunity of hearing. It is also made clear and consequent benefit so and so to reiterate that his statement would be only for the purpose of holding the fresh inquiry. Now, after that, my lord, we have removed once again. So that record will be necessary to bring you to your lordship. Now, after that, they filed the writ petition saying that this may be, my lord, looked into by the appellate authority. Now, appellate authority has passed an order. It's a mercy order has been conferred to him. He is not entitled for that. Whatever happened, happened. Now at this stage, why they have come? That's why I was, my lord, repeatedly saying at page 161, at page 9. This is the bone of contention so far they are concerned. Now removal on all that are not there. Rejection of representation of delay in submission by the delinquent employee being challenged at the Honorable High Court, Guwahati, WBC number so and so, as per order of the Honorable Court, to consider the appeal on condemnation of delay is considered. Further, on thorough review of the representation, the earlier order of removal from the services of the company, which shall not be a disqualification for future employment, is amended as setting the delinquent employee to the initial basic pay as assistant, subject to recovery of any loss for claim from the date premium was collected, and up to the date of recovery to be treated as personal recovery from the employee. Now, this is the line, Milo. The period from the date of his suspension to the date of removal of his service, as such, to be treated as continuation of service. It was wrongly given. Then, my lord, we made a correction at page 162. This is addendum. Further to our earlier order dated 8/3/2022, reinstating your services to initial basic, the intervening period for the date of termination till the report of duty will be treated as period not spent on duty and hence loss of pay. So that is the area only, my lord. For this reason, they have come before your lordship. Now, this was, as your lordship has seen at page 161, this cannot be the proposition of the authority. They wrongly gave it and they corrected it. Period from the date of suspension to the date of removal of his service as such to be treated as continuation. This cannot be to be continuation of service. So they have corrected it by saying that this period will be spent on, will be treated as period not spent on duty and hence loss of pay. We are on that, my lord. This is the small area where your lordship is required to advocate.
Now you come to the prayers, your prayers. You are challenging the memorandum of chart, which is the first one.
Right.
Then the inquiry report.
Right.
Then the letter of disagreement.
Right.
Then the removal.
Right.
And finally the appellate. Now from 1 to D, these were already addressed by the court earlier.
Yes.
Where is the occasion for now making a fresh prayer?
Yes, lordship has told. Then the office order dated, it is the addendum and appellate authority addendum. Appellate authority addendum.
No,
Because-
appellate authority
Because,
is
because
this.
my interpretation is that
Huh.
that prior to appellate authority's order, there is a removal order.
No, all these are set aside
No,
by the
this,
single bench.
this removal order was not set.
What was set aside?
They again or imposed the penalty of removal. After furnishing disagreement note, they again imposed the penalty of removal.
But that was recalled.
No.
Then how?
Now appellate authority.
Uh,
Now appellate, if my appellate authority order goes, then removal order will remain.
My lord, your lordship only see prayer portion.
then you are again praying for the holding the entire disciplinary proceeding initiated to be null and void.
No, that my lord, I am living up to your lordship. But
No, no.
removal,
We are asking you, what are you challenging in the
removal.
proceeding?
My humble interpretation is that if appellate authority order goes, removal order will be there.
How? It is merged with the order of the appellate authority. It
No,
is merged with the order of the
they
appellate.
have passed the first removal.
Your first removal order was the penalty imposed to set aside.
Settled.
It was upheld by a division bench.
Yes.
Then
Then they have imposed again removal.
removal. Then you went in appeal. Appellate authority modified that and
And impose this penalty.
imposed whatever
And
penalty.
only if your lordship, understanding is that only if your lordship set aside I am understanding that set aside this order, appellate authority, then my lord, removal order will.
No,
Wait.
that is in the event we are setting aside. If we don't want to set aside, we want to dismiss your petition, nothing.
That will do. That is another aspect. My lord, because the charges, the 1 and 3, they are holding that these charges are still proof, that misappropriation. Where is that finding that misappropriation and these findings has been upheld? Page 161, para 7, man. Para 7 is the base of the penalty, now appellate authority. Still holding that charges are proof. Misappropriation still holding that proof.
Then your lordship can set aside this order, then he cannot work. His prayer is there at page 50, your
Yes,
lordship can
removal order, that is what I am telling.
The office order dated 8/3/2022 of the appellate authority and addendum dated so and so. My lord, these are to be quashed.
Yes.
Then how he can work? The removal order come up then.
Then that is what I am telling the removal order. Rightly said.
161 has protected him, and if he thinks that your lordship to set aside this order, then removal order will come up.
That is what I am telling the removal order. Set aside the removal order. Because removal order findings is that all the charges.
Charges proved, you have admitted.
All the charges I have not
Well, he want to bring back all the things is good, my lord.
I have not admitted all the charges.
See page, my lord, your lordship kindly see what he has admitted. He is seeing that he is not admitted. Now at page 54, your lordship kindly see. I took a sum of rupees 1 lakh so and so out of the daily insurance premium on various dates to meet my urgent and unavoidable needs without malafide intention. Very candidly, he has accepted that position. Then, my lord, in a given case in 2021, the bus conductor, he swallowed 106 rupees only. He was dismissed from the service. This is the position of
In
law.
the inquiry officer finding, it is still holding.
He is lucky that the company has reinstated him.
Where is the misappropriation? Inquiry officer has found that misappropriation not true. And that is findings of the Honorable Single Judge in RDL litigation. Still, they are holding that these are true, ignoring the findings of the Honorable Single Judge and division. Still arguing that the misappropriation true.
All right, the misappropriation, even if we hold that misappropriation is not correct. Conclusion. What about charge 2?
That, my lord, I am coming to page 161. This is under telling. Again,
Charge 2?
again.
Yes.
As stated above, the Honorable Court by order dated 30/11/2020 and has disposed of the aforesaid writ petition and direct the ability to decide the petitioner's appeal on merits within a period of 3 months. The relevant portion of the aforesaid order has been already reproduced and beginning order. I have para 7. I have carefully examined the submission in the appeal and accorded my response thereto. Stated above, I noticed that there is adequate reason to hold the charges true. Based on the principle of preponderance and propriety, that the has violated the company's norm by not depositing the premium money on the time, and thereby company has suffered a loss interest income with the compliance of the Section 64 BP Insurance Act. However, in view of the facts of the matter, and there is no direct financial loss premium income to the company, so the penalty imposed by disciplinary reviewed in the interest of justice. Now, my lord, again say holding the basis of this order is that charges has been proved, interest premium loss. There is no such findings in the inquiry report. There is no what amount of the interest loss and how lost. Because the Honorable Single Judge in earlier light of litigation, categorically the major portion deposited on the 30 to 14. How they came to come to the conclusion? What is the interest amount? What is? These are only basis assumption and presumption. 64 BB loss, some loss. Where is this? Well, where is the findings this in the inquiry report?
finding has been, that no fresh inquiry was directed to be held.
No, I am not saying earlier inquiry.
Where is that earlier inquiry report?
I am inquiry report. Page 67. Page 68, I am coming. Having received the appointment letter from the competent authority, the inquiry into the charges level against the delinquent, the undersigned informed both the delinquent and the representing officer to attend the NERO Guwahati so-and-so officer dated need. But the delinquent and presenting officer attended NERO on the date fixed for proceedings of the inquiry. On the same day, the delinquent has explained the charges level against the delinquent who he denied, and hence inquiry was posted for recording evidence for the prosecution side. On 7/12/2010, the evidence of PW1 Biswajit Dev is a senior assistant was examined, and his evidence was separately recorded, which is tagged with the record. The presenting officer further exhibited some documents mentioned in the charge sheet, and delinquent was afforded the chance to cross-examine PW1 and Biswajit Dev and cross-examine and said witness. On 29/12/2010, presenting officer examined another witness, PW2C Sanjeev Pal, by manager NERO in presence of the delinquent. His evidence was recorded and tagged with the record. Delinquent declined to cross-examine PW2. I have gone through the written brief submitted by the delinquent Chief Pradipacharika and presenting officer Chief P.K. Chakraborty. Mr. Pradipacharika argued that he could not held guilty as because he supplied the list of witnesses proposed to be examined to sustain the charges framed against him, and thereby he likely prejudiced. On the other hand, presenting officer argued that after considering all aspects of the delinquent, Mr. Pradipacharika is then found guilty for violating the company's norms. On closure of the proceedings, the delinquent was asked to produce defense witnesses if the delinquent did not examine any witness in support of his defense, and hence the evidence from both the sides closed and the case was posted for filing written from side. I have gone through this entire record, the evidence and written brief submitted by both the parties. So far, the charges of misappropriation of company's money, that is premium amount the delinquent allegedly not deposited during the period 29/2009 to 31/12/2009 was mentioned in charge number 1. PW2 Sri Sanjeev Pal stated that this is important, he was not aware about non-depositing premium due to system failure. This is important. He further stated that premium was deposited by delinquent to the lately on 21/1/2010. PW1 stated that he detected about non-deposit of daily cash to bank after doing bank reconciliation. Thereafter, he reported it before the competent authority. He also stated the account not deposited was related to cash only and check were timely deposited. They included all cash charge amount. He further stated that after reconciliation bank statement, the collection amount account, he found shortage an amount of 2,65,289. He further stated that on 2/9/2009, out of total collection of 36,290, the delinquent deposited rupees 2,71,004 on 4/9/2009. That is 29 and 49. And the rest amount of 9,186 deposited on 21/1/2010. He also stated that amount of rupees 117,300 collected on 39/2009, delinquent deposited on 21/1/2010. He further stated that on 7/10/2009, the delinquent received on rupees 65,075 and not rupees 65,078. As stated in the chart sheet, is deposited on 21/1/2010. He further stated that on 30/12/2009, account of deposited to 82,905 was collected by the delinquent. He was deposited at 1/1/2010, 30/12 and 1/1/2010, and 31/12/2009. A sum of rupees 8,033 was collected, which was deposited on 2. They have taken entire this matter, entire amount that was missing. In cross-examination, stated that due to failure of network system,
What is RA 16?
could not be generated.
RA 16, Mr. Dr. Some RA 16 could not be generated. What is that?
RA, I think, my lord, is a bank reconciliation statement, maybe. My lord,
Yeah, the records will be necessary.
my learned friend trying to pursue your lordship, the delay for 1 or 2 days. The lordship kindly see the charge at page 60.
No,
My lord, He should come down to little truth telling in the before the court, my lord. Because after all, my lord.
We'll examine the record.
Yes, yes.
I am
Now,
reading-
for a file, your
I am
lordship
reading
kindly
for
see
inquiry report, my.
page 60.
I am reading for inquiry.
No, no, an inquiry report, but then see the chart.
Submission of the.
You're saying will not.
This is the submission of the prosecution.
See, my
not
lord,
my
page
state.
60, my lord,
Not my
the article of charges.
Yes.
My lord, the last portion, your lordship kindly see. 36,290 deposited 4 months, 20 days late. Then second one, 17,000 and something deposited 3 months, 18 days. Likewise, my lord, 1 or 2 days where they are saying, this is the last item, 82,000 deposited 1 day late, 83,000. These are the two circumstances, my lord, 1 or 3 days delay. In others, my lord, your lordship will find 4 months, 3 months, 2 months like that. Now he is reading there is a delay of for 1 or 2 days only. And he himself stated in his, my lord, the reply that I utilized 1 lakh for my own purpose.
Reading from the statement of the prosecution.
I am also reading from the record. What
get
you
the
say,
record.
that cannot be the
We'll have to
gospel
examine
truth.
the record. We are concerned with charge 2 only. Now,
Yes. And that has been emphatically proved.
that's what you'll have to.
Your
If
lordship
you come
kindly
to page
see.
number 69.
My lord, 1, 2, 3, these are all same charges, late deposit of the premium
No, no.
amount. My lord, he is a cashier of the
One is the
institution.
1 and 3, there is an finding by the single judge
Yes.
that the charges were not specific, etc., etc. Whatever it may be. You went in appeal, appellate authority also, appellate court also did not interfere with this finding, specific. What was left is charge number 2. Charge number 2 is the charge of deposit,
Late deposit.
late deposit.
Yes.
So,
My lord, late
whether
deposit.
late deposit
Yes.
is proved or not, so that will
Yes,
be the
yes.
record.
Yes.
And if it, assuming it is proved, then whether the order passed commensurates, whether it is a misconduct, whether it commensurates.
Yes, yes. My lord, if
As
that
far as
remains,
1 and 3 are concerned, I don't think in view of the findings, there is any scope for reopening this issue again.
my lord, if 2 remains, still misconduct is there because this is the admitted position. Well, from initially I've been saying that these are all, my lord, adjudicated matter. The only thing we have wrongly said that this period, my lord, as I stated earlier, this is only their contention, my lord. The period from date of suspension to the date of removal of his service as such to be treated as continuation of service. This was wrongly given, and we have corrected it that this period, the report for duty will be treated as period not spent on duty. Now, this is the portion which your lordship will like to adjudicate. Other parts are all over.
No, charge 2 is open.
My lord, in that case,
We'll have to examine charge.
yes, very welcoming position, my lord. And if the charge is proved, then my lord, your lordship will see that he should be punished for.
Subject to correction from the bench. My understanding is 1 and 3, there is no scope to re-agitate this issue because it is already settled in view of
Yes, yes. 1 and 3, if goes away also, 2 is sufficient to
only
punish
thing
him.
is that in regard to charge, liberty was granted for a friend.
My lord, I'll satisfy your lordship. If your lordship satisfy, so far charge 2 is concerned, if it is proved, it is sufficient charge to impose a punishment of dismissal. If it opens, my lord, is good for us. Because he is a person who is should be punished only because of the CMD he was reinstated. It was unnecessary mercy or sympathy
Produce
shown
the
to him.
records will examine it again.
Yes, yes.
When can you
My lord, after 1 week.
uh, not have it after 1 week?
Date, at any date, July 10th or 17th, July 10th, July 10th.
Hmm?
July 10th.
July 10 will be
Sorry, June 10th.
holiday.
Sorry, June. We are in June.
What is 10? 10th of heard counsel for the parties during the course of the hearing. The question we decided according to the court, will require a perusal of the records of the bank. What is this? Corporation
New India Assurance Company.
company to examine the propriety of the inquiry conducted. To examine uh, the findings of the inquiry officer. Let the report be produced again by the next date fixed on 10th, as agreed to on 10th of June.
Your Lordship will see only whether the charge number 2 has been established or not.
I don't know what I'll see, but I'll disclose
No, as I could understand, my lord.
whatever I
from the-
wanted to disclose, I have disclosed.
Yes, yes.
Rest upon
All right, all right.
when I see the records, I'll
I could get your lord.
the subject. That is why I said you please go through the orders of the single bench and the division bench. Single bench has returned a finding that this is sufficient or not sufficient, whatever it is. That finding has not been interfered with by the court, by the division bench. What is left open is charge number 2, according to me.
Yes, yes.
And there is no fresh inquiry directed. It is to be continued from the time of handing over the disagreement note. So therefore, no fresh inquiry is called for. It is only on the findings that the
In
authority
fact,
has to return a finding whether you are guilty or not guilty.
yes.
How disagreed, whether disagreement is support of the evidence.
All these things are there on record. There is no doubt about it. And if charge number 2 is proved, then my lord, he will have to get the punishment. my lord.
We don't know. But 1 and 3, you may look into it and address the court again that 1 and 3 is also open or not open, as the case may be. But prima facie, I find that perhaps 1 and 3, in view of the findings of the single judge, may not be open. Again,
My lord, only thing I will submit, if 1 and 3 goes away also, 2 is sufficient.
therefore, we are asking for the record.
Yes, yes. And I will
Otherwise-
satisfy.
Otherwise, we would have closed it today.
I did not argue on all that because the area was very small. As I have shown you, those when the suspension period, my lord, they have said it will be treated as spent on duty. So we have modified that. Now, if you want to argue all that, it's better. Your lordship will see if the charge 2 is proved. Then, my lord, we are
No,
open
first-
to punish
first,
it.
the cost of repetition, I am saying that prima facie it appears to the court that out of the 3 charges, 1 and 3 are not required to be gone into in view of the findings of the court earlier. You may address the court, say that no, it's still open
Right,
because of this interpretation.
Right.
Prima facie it appears that only on number 2 that inquiry was permitted to be continued after supply of the disagreement. So you have continued. Now, whether charge 2 is actually proved on the basis of the evidence, first question. If not proved, matter is there. If proved, then the question of whether the punishment imposed
Yes,
proportionate.
very correct.
This is how I propose.
My lord, my lord. My lord, satisfy your lordship by placing some appeals court decision also.
Yes.
In such a circumstances, only punishment is
And
dismissal.
even at the end of it, even if charge 2 is proved and the authorities have gone ahead and imposed the punishment, whether it is a proportionate punishment, that is also to be seen.
That's why, my lord, at the beginning I have said, these are all gone matter. Is not required to be adjudicated because we have already reinstated him.
So most of the prayers are not required to be gone into, therefore, right?
And the prayer, very curiously enough, your lordship will find one prayer. If it is set aside, he will be out of service. He wants that only.
That is why
Prayer portion E, my lord. He wants that the order passed by the authority reinstating him, that also to be quashed.
No, that will decide what to pass. What orders will pass. All right, heard again, list on 10th.
10th, your lordship has fixed. All. Obliged.
Yeah.
the method and sometime this method item 5 art force method, and this is the my lord, the basic issue is that where is the charge, my charge and the penalty under section 39, 40, 41. So my humble submission that section 39, 40, 41, it's all these penalty of the pay fine, RI, rigorous imprisonment, subject to the outcome of the court martial proceeding, this act itself says. The act itself says. And now, my lord, in their affidavit, they have enclosed this. And all these, my lord, these are for the forming of the tentative charge sheet. For framing of the tentative charge sheet, they are record saying. So only lordship is to look into whether section 3940 says a penalty to be imposed.
Army Act,
Army Act. Because this
Army Act and rules. Yes, our section.
section 39, because the then charge is on the based on section 39. If the charge is on the section 39, whether section 39 procedure is followed on.
You are saying it is court martial.
Yes.
Sorry.
My humble submission is that from reading of the section 39, absent without leave.
Conviction by court martial.
Conviction by court martial. Then you can impose. So there was no court martial proceeding. And after the section 39,
Where is the provision of court martial?
that portion of court martial provision, my lord, there in the act. Army Act, my lord, 108, kinds of court martial. And law also, my lord, the Honorable Supreme Court 2013 has said court martial proceeding according to the CRTC provision, because a court will be framed prior to this court martial. 108 kinds of courts martial. For the purpose of this act, there shall be 4 kinds of courts martial, that is to say, general courts martial, district court martial, summary general court martial, and a summary court martial. Then, my lord, power to convene general court. Who can? Because section itself saying you can impose the penalty after findings of the court martial proceeding.
So you are saying that court martial is also applicable for civilian employees.
Because there, my appointment clause says that for the disciplinary purpose, I shall be governed by the Army Act. All the penalty has been imposed based on section 39 and 40.
Where is the order?
My lord, the order, they have not passed any order, nothing. They have, I repeatedly, I am getting the lesser salary. That is, thereafter I submitted a representation. After submitting of representation, then why I am getting less pay? That they have replied, and that reply is, my lord, that pay. At page 134. They replied that why my pay, I am getting less pay. Because nothing is applied to me. Punishment awarded to you
What is the punishment awarded?
that is here is 130. only this page, like
132,
34.
34.
Representation again, letter issued under number so and so dated 20 October 2020. He submitted a representation why I'm getting less pay repeatedly. My pay is with that. They said that two para one
You are not terminated.
not terminated. They have a pay fine import. A 14 days pay fine was awarded by 5682 ASC and battalion for being absent without leave. 20 days RI and 14 days pay fine on 9 December for disobedience of orders and misbehaving with the appointment of the battalion. Then 7 days pay fine awarded based on report received from 22 FPR by letter number. Then 9 days RI and 9 days pay fine 28 in foregoing signature of the vehicle mechanic in your card ID and letter trying to investigate. 3 days RI on 27 days for social media violence. They have imposed all these penalties, and for the imposition of such kind of penalty, and they have issued a tentative tax. The tentative tax which says they have also included in their page 101.
Yes.
Page 101. It intimated that you have been charge sheeted on 9 December 2022 and finally awarded 28 days RI and 14 days pay fine for following charges. 5 December 2021, charge 1, without sufficient cause failing to appear at the time of fixed at the place appointed for duty. That is under section 39D. Then charge my lord under section 40C, Army Act. Then on 6 December, it is disobeying such a, under section 51(1), then section 39E. That is why, my lord, I drawn your lordship and attention on the section 39. What is section 39 say? 40 say, 41 say.
Yes. Your affidavit does not highlight on the procedure.
Lordship, first Lordship kindly come to page 157. I will show how it is corroborated with the sections and rules, Lordship. So I'm reading paragraph 15, Lordship. So and so reaffirms the statement so and so. The petitioner that he is a civil employee, hence Army Act 50 is not applicable to him is not correct. First, his allegation is that he is not entered under to be considered under Army Act. That is the prayer he had made. Petitioner will be governed by Army Act 1955, Army Order number 141 of 72 for discipline purpose. So the affirmation of the petitioner that he cannot be tried under Army Act 1950 is absolutely incorrect. Whenever a charge is levied against an individual subject to Army Act, then as per Army Rule 22, hearing of charge takes place. The procedure is as given below. Here, the case of the petitioner is considered as summary trial. Lordship, 4 kinds of court already Lordship shown that summary trial court is there. So now his case was considered under summary trial. Summary trial is a form of disciplinary action. Hence, hearing of charge under Army Rule 22 read with Army Order 6 of 2009 must be held before the accused is matched up for summary trial under section 80 of the Army Act 1950.
Where is it? Kindly show us this
Rule,
provision. Rule 20.
yes, Lordship, Rule 22.
Rule 22.
Rule 22, hearing of charge. This is the power of the commanding officer. Every charge against a person subject to the act shall be heard by the commanding officer in the presence of the accused. The accused said,
You will have to correlate with section 39, because this is a question of absence without leave.
Lordship,
So therefore, the proceedings to be continued in terms of the act is by a court martial.
this the Lordship may kindly read paragraph 22. When court martial is necessary, when not, Lordship. Heard by the commanding officer in the presence of the accused shall have full liberty to cross-examine any witness against him and to call such a witness and make such statement as may be necessary for his defense. Provided that where the charge against the accused arises as a result of investigation by a court of inquiry, wherein the provision of Rule 180 have been complied with in respect of that accused, the commanding officer may dispense with the procedure in Sub Rule 1. So now Lordship kindly come to clause 3. After compliance of sub-rule 1, that is, I have read hearing of charge, if the commanding officer is of opinion that the charge ought to be proceeded with his cell within a reasonable time, dispose of the case under section 80 in accordance with the manner and form in appendix 3, or refer the case to the proper superior military authority, or adjourn the case for the purpose of having the evidence reduced to writing. If the accused is below the rank of warrant officer, order his trial by a summary court martial. So if one is applicable here, dispose of the case under section 80 in accordance with the manner and form in appendix 3. So he has the power to dispose it under section 80. If he is not willing to dispose it, then the following procedure will come. So now I will come to section 80, Lordship. And that is the punishments are under section 80 and 82, 80 to 82. Punishment of person other than officer, junior commission officer, and warrant officer. Subject to the provision of section 81, a commanding officer or such other officer as is, with the consent of the central government specified by the manner proceeded against a person subject to this act, otherwise than as an officer, junior commission officer, or warrant officer who is charged with an offense under this act, and award such person to the extent prescribed one or more of the following punishment, that is to say, imprisonment in military custody up to 28 days, detention up to 28 days, confined to the line up to 28 days, extra guard or duties, deprivation of a position of the nature of an appointment or of corp or working pay, and in the case of non-commissioned officer so and so, forfeiture of good service and good conduct pay, severe reprimand or reprimand, fine up to 14 days pay in any 1 month, or penal deduction under clause G of section 91. So section 91 clause G says about the penal deduction. So here the punishment is some rigorous imprisonment and penal deductions. The commanding officer has the power. If he had not disposed it of, then it will go for further trial. That is what I have stated in my paragraph 15, Lordship. He himself had disposed it of by giving all the opportunity to the petitioner, Lordship. The punishment and charge I have stated at page 153. The section 39 is applicable for all, but if he is a warrant officer or junior commission officer, then other procedure will follow. But for a person other than that, the section rule for 22 read with rule 80, section 80 to 82. That is absolutely followed in this case.
Yeah.
Summary trial is there.
So you are saying that before court martial, there has to be the process of hearing.
Yes,
Decide.
yes. And the commanding officer may dispose it. He had done that. Because its lesser punishment was given, so he has the authority and power.
Yes, I am not disputing that commanding authority has power or not. I am saying that you have issued the charge sheet under some specific section. What that section says the court martial. Now it's section 81 says the commandant has the power. I am not disputing that. Power had not. I am saying whether section 39 your charge and section 39, 40, 41. All these sections say that to impose any of the penalty, you have to follow the court martial procedure. I am not disputing section 80 and it is the power delegated to the commandant. I am not disputing the commandant may impose the power, exercise the power action section 80. But whether they are charged in the charge, they cannot move the goalpost. Their goal is that you are to be penalized by the section 39.
This is if you see the punishment.
Yes.
Section 39.
Yes.
Talks about a punishment for imprisonment for a term extending 3 years.
And they have rigorous examination. Now, all these section 39.
On conviction by a court martial.
On conviction. Section 39, not only this, absent himself duty without leave. Charge is that action duty without leave.
How are you prejudiced?
My lord, the court martial procedure was not followed first one. Second,
So how are you prejudiced by
that is what the section says the court martial, because if there is a court martial procedure, those who has been placed as a witness, I has categorically alleged that they have done these things against me.
Hmm.
And on the same day, 5th day, 6th day, next day, they brought those persons.
Was there any proceeding? Was there any hearing?
Yes, Lord. I have annexed those documents. So I have given all opportunities to the petitioner.
Where are they?
Lordship makes it. This is 207.
207.
Yes, Lordship. Witness's signature from 207, Lordship. There is an appendix, and in that format, we have done everything. 207, from there, all those I have annexed. He had refused to sign, but witness's
Is there any
signatures are there.
admission that was there any admission on his part?
What the charge they have reiterated it. Only charge they have said. These are the charge. And what the witnesses says, nothing.
Lordship, here we have stated, we have asked him for whether he wants to examine any witness. He declined, Lordship.
Where is the statement of the?
Because he had not, witness's signature are very much
Yes,
there,
yes.
Lordship.
Where is the statement of the?
We have page 2215 also there.
Where are,
Charges against the accused were read out and explained to him, and he was also heard for the charges. However, the accused refused to endorse his signature on this document, and the witnesses just signed. And this rule 22 says that you have to hearing of charge.
Get the record. Show us that in the proceedings the witnesses were there, they had signed, they had appeared. Yes.
That I have annexed, Lordship.
No, you have any. Where are the signatures of the witnesses?
Witnesses' signatures are below, Lordship, below of the pages. Name and rank, etc. Everything is written. Page 207, page 208, all pages.
Where?
Page 207, 208.
What is the colonel commanding officer?
This signature of witnesses, Lordship.
Signature of number 1.
Yes,
This
number 1 and number 2. Then page 208 is also there. Signature of number 1. Then page 212 also, Lordship. All pages 212, 13, and we have also stated that he had refused to sign.
Yeah.
So all the procedures have been followed, Lordship, and still after the interim order also he is still violating all the rules, Lordship. It is still continuing.
There is any appellate provision against the orders part?
The appeal he had preferred already. That was rejected, yes.
That was also rejected.
not rejected, not rejected,
Not yet.
not rejected.
You have
Nothing,
not heard case.
nothing.
He had submitted representation. Representation he has submitted. And those representations, we have replied to those representations. I have annexed some of the representations. Yes, annexure page 171 to 178. Yes, and appeal again detention in Quartaka. These are their lot. Appeal he had preferred 171 to 178. (175) second application for seeking justice. That was also we had replied. That is a absolutely discussing everything.
Page 173, ma'am. Really look it. Summary evidences were collected.
So the procedure was followed.
No, my lord, page, I'm going to there.
Your argument, your primary argument that section
No.
39 is violated.
Put section my, because the charges framed under this specific under this section. So we
Are you relying on any authorities to support your contention?
my lord, the court martial, because the court martial procedure authority is there.
Are you relying on any
No, I am saying that since the section 3940 charges are on the basis of those section, not under section 81. Since the section 31, whether this section has been followed up, not section under 81. That what the other side saying that section 81 has
No,
the
no,
power.
section 39 is in respect of a very specific
Yes.
punishment,
This
imprisonment.
RI, I have been imposed penalty of RI, ridiculous imprisonment,
Imprisonment for a term which may extend up to 3 years.
which may extend. I have
Uh.
28. Then any kind of fine without leave from his superior.
How are you prejudiced by not having
Because if
the
there
matter
is
being decided by the court?
because more likely kindly look into how they have collected the evidence and witnesses. There is no statement of the witnesses. They have just said witnesses are present.
You get the record, let us see.
Witnesses are present. Witnesses are present. They are present and signed. What
That
their
is the
statement?
summary trial. Summary trial procedure is that, and I will produce the record, no
There must be
problem.
something to say that this is what the witnesses that said.
Yes.
Otherwise, what is the point in having a trial?
He had not cross-examined. Definitely, there must be
Yeah,
something.
but should be there.
Yes,
There.
yes. From the authority, when you produce somebody,
Lord.
whether he is you will have to cite it, must be there on record. Whether he agrees or disagrees, that produce it. Third conflict for the parties. The challenge made in the writ petition is the order passed by the commanding officer, imposing punishment. Stop the preliminary as a state this proceedings, the proceeding as well as the order on the ground that violative of section 39 the Army Act 50, whereby for suffering imprisonment to term of 3 years, the court martial proceedings are initiated. It is submitted that court martial proceedings were not initiated and the inquiry proceedings were conducted by the commanding officer and punishments accordingly have been imposed, and which position on fact not disputed by the respondent. However, the pleadings before the court not reflect the proceeding of the inquiry conducted by the commanding officer, including statement stated to have been made by the officer against the defendant. Under circumstances, if the appropriate, directly respondent produce the records pertaining to the list again on
24.
Well, not on 23, 24. Not on 23rd, 24. I'll
that is good, right? It's on 22nd of July,
20.
along with enabling the respondent to
Second.
produce the reports.
July
22nd.
of light.
Obliged.
Need to Lordship, Mr. Dinath is on legs, Lordship. After some time.
But the first writ petition has already been, my lord, your lordship has heard, my lord. Supposing, my lord, your lordship has disposed of
That is the gratuity.
gratuity, my lord.
Second,
Second is the leave encashment, my lord. I will take 1 minute, my lord. One provision, my lord, they have
let him
misquoted.
come.
Yes, my lord.
Timely. Timely.
Send them. Send them.
Oh, Lordship, I have a criminal appeal also today. It will be difficult time being, Lordship.
Item be passed over for the day. The request made by the council
Date may be fixed, Lordship. After one.
passed over.
Plus,
arbitration matter. On last occasion, your lordship heard to some extent, my lord. And in this particular case, my lord, again, I am taking to your lordship to the close.
Partnership.
Partnership.
partnership. There are allegations of fraud.
Fraud, even though, my lord, whatever may be related for that one, my lord, I beg to refer the judgment which I have already given to your lordship, my lord. 2024 6 277 277.
You are filing an application seeking appointment of an arbitrator.
Simply,
In
my
view of the, in
all
view,
these questions are to be decided by the arbitrator, whether it is a valid one or invalid, or whether it is like all these things. Even though, my lord, I am taking to your lordship to judgment 2014, my lord, to store. And for that particular purpose, my lord, your lordship will come to para 18 first. Para 18, my lord. That is very important, my lord. Para 18 and 19.
yes,
Para 18. Having found that subject matter of suit was within the jurisdiction of the arbitration, it was held in such and such that the dispute cannot be referred to arbitration. This court approved the finding of the High Court that since case relates to the allegations of fraud and serious malpractice. My lord, the same allegation. Fraud and serious practices on the part of the respondent. Such a situation can only be settled in a court through furtherance of detailed evidence by either parties, and such a situation cannot be properly gone into by the arbitrator. In my opinion, this is very important, my lord. In my opinion, the apostate observation run counter to the ratio of the law laid down by this court in such and such and such. First, next, my lord, your lordship will come.
yes,
Oh, that is a para 24, my
para
24.
24.
Yes, regarding fraud and only this one.
Yes,
Keeping in view the apostate observation made by this court in such and such, I see no reason to accept the submission made by the learned counsel for the respondents that since a criminal case has already been registered against the chairman of the organizing committee, some other officials of the petitioner, this court would not have no jurisdiction to make a reference to arbitration. So, my lord, it is not in a dispute, my lord, whether the case, because so far the criminal case is concerned.
what is the stays here? Some criminal matters have been filed.
Yes, madam. With my affidavit in opposition, I have annexed the FIR. Yes. Page 51, running page
51.
against the respondent as well as another person. Yeah, who is not a partner.
What are the sections here?
My lord, section
What is the dispute between the parties now,
section.
which requires arbitration? What is the dispute for which you want the matter
Pardon, my lord.
referred to arbitration?
Dispute regarding the misappropriation of funds.
How can it be decided by an arbitrator?
Yes, that can be decided.
How?
How? Because they have to go through the accounts and come to a particular finding.
They don't have powers repose on a criminal court.
My lord, so far the misappropriation, that cannot be even be decided by the criminal court, my lord. It can only be decided by competent civil court. Your lordship may say otherwise.
Correct.
And the same position is here. in arbitration, it can be decided if there's misappropriation. If there's no misappropriation, where is the scope of filing the application to go for arbitration?
You
Until
show us-
unless,
you show us some authorities to that effect that it can.
yes,
be
my
decided.
lord, this authority is
Where does it
absolutely
say?
applicable.
Where does it say?
Yes, your lordship will come again, page this judgment 2014, my lord.
If you have read para 18,
Para 18.
where para 18 has approved the finding of the High Court that since there are allegations of fraud,
No, the issue by page 69, sorry, my lord. Page 688 relates to allegations of fraud and serious malpractices. It can be said as the misappropriation. Malpractices means the misappropriation. On the part of such a situation can only be settled in court through furtherance of detailed evidence by either parties, and such situation cannot be properly done into by the arbitrator. In my opinion, the approach of observation runs counter to the ratio laid down by this court, wherein this court in observed as follows.
there is a civil suit also pending.
No, man. No, sir. Because I cannot go. Since the arbitration clause is there, and this matter can be decided, let it be decided by arbitrators, whether they can go regarding the misappropriation and malpractices, because these are the matters to be there. Otherwise, there is no question of.
And if it is not pending before the arbitration, you have to go somewhere. I mean,
Before the civil court.
either it is pending before a civil court, and you say that these are issues which cannot be decided. But there is a mandate that if it is the civil court, refer it to arbitration.
No, man, that cannot be, because these issues, the dispute, whatever dispute regarding misappropriation of fund, not only by the one of the partner, here in the respondent, but some third parties are also involved in this.
Not in arbitration case, my
Some
lord.
authority will have to come to a conclusion.
My
that
lord.
there was misappropriation, not misappropriation, the amount payable. It can be done by a criminal court. Either go to a civil court.
Civil court, my lord,
Or-
not in arbitration, because it's.
But if you go to a civil court, view of the arbitration clause, it will be referred to arbitration.
No, your lordship will clarify that.
Why should we clarify that? Then we'll have to return a finding on merit.
If your lordship, asked me about the
Once
section.
we file a civil, view of the clause, we refer to arbitration. It's only when the
If in
arbitration
section like 8 is been filed.
that either for citizen or death reason we can't decide, the matter will come back.
I have, if it is filed, section 8 is filed.
If it is filed,
It
that's
is
right.
filed.
So if it is not filed,
Then
and we see an arbitration clause,
our contention is,
ordinarily it should be referred to the arbitration.
my lord. But our contention is that, first of all, this arbitration was, this partnership was dissolved by, in view of the section 43 of the Partnership Act. And if a partnership is dissolved under 43 of the Act, Partnership Act, there doesn't exist. I have an authority of Gujarat High Court which says the arbitration also, the partners cannot be forced to resort to arbitration. And regarding the other thing, these are the disputes which has been projected before your lordship are all.
Where is the Hindustan Petroleum judgment?
My lord, I have not in my possession, but very recent judgment of the Constitutional Bench of 7 judges of the I have.
Interplay. Which one?
Even the plate. कौन सा paragraph? Regarding his submission that it also goes, my
Interplay.
yes, interpret. My lord, your lordship may directly come to paragraph 98.
Huh?
90.
98. Yes.
The concept of
No,
separability or
the
severability.
separability of the agreement is not in
Not
question.
in question.
Question here is in the view of allegations of fraud.
Yes,
Property
that I have already
arbitration.
shown my note from the last judgment that it showed. This matter can be decided.
No,
Let
no, no.
it
You
civil.
go through that. You bring that Hindustan Petroleum judgment.
My lord, just it is not.
Huh?
Just it is not in my position. Let it come day after tomorrow.
We'll get it for you day after tomorrow. All right.
Day after tomorrow. Let it be. And let it be the
Let it be
first.
on Friday. Friday.
Yes.
We'll have it on Friday.
Yes.
Heard. Counsel for the party. It is set on Friday for further hearing. Enabling the counsel for the parties to place relevant judgments that they have.
Let it be kept as a part of my lord, so that it may be.
It is only this
It
bench.
may reach a earlier one.
This bench which will take up the matter. So judgment will be good.
Much obliged.
A judgment will be. A- Yes. Where any submissions completed or
The submission for the respondents that was completed on the last occasion, and I'm supposed to, Milord, give my reply. So the first proposition of law that, Milord, that I placed before your lordship was with regard to that there is no provision made in the Assam Service Disciplinary Appeal rules for de novo inquiry. So that was my proposition, and for that proposition, Milord, I submitted 3 judgments before your lordship. One is Moloy Bora, second is Bidyut Vikas, and third one is Sonmoni Singh.
Molloy Bora?
Milord, may I give the process perhaps recorded?
I think we must be having, just tell us the name.
Yes, yes. Moloy Bora, then Bidyut Vikas. Bidyut Vikas full name, Milord, Bura Gohai. Bidyut Bura Gohai. The copy to Atul.
Yeah. And then
And Sonmoni Singha. So what my submission is that, Milord, in Moloy Bora, then Bidyut Bura Gohai, the Milord,
that additional AG has argued that there is no proposition laid down by the law of universal application that there can never be a de novo inquiry.
I am coming to that, Milord. In these 2 judgments, Milord, 2 proposition of law has been laid down by this honorable court. One is that if there is an inquiry report in favor of the delinquent charge officer and disciplinary authority is not agreement with that inquiry report, in that context, the disciplinary authority cannot go on with another new inquiry until and unless he deserves satisfaction on that particular report. That is one set of proposition of law that has been held by this honorable court in these 2 judgments. Another set of proposition of law is that, Milord, there is no provision in the Assam Service Disciplinary Appeal rules for holding de novo inquiry. That proposition of law has not been addressed by the respondent. The earlier one the first one they have addressed, saying that
He is addressed by saying that where procedural impropriety or defects are noticed, they can always go for and recorrect it because
no, what
that's
my
your submission.
what my senior submission is that, my lord, on the last occasion, these two judgments are distinguishable on the point that in these two judgments, factual distinguishment, in these two judgments, the inquiry report was in favor of the charged officer. And since it was in favor of the charged officer, disciplinary authority disagreed with the report of the inquiry officer and derived a conclusion for de novo inquiry. And this honorable court in that factual situation has held that you cannot go for one after another inquiry in the guise of holding de novo. In the guise of holding de novo. That was one proposition of law. At the same time, on the law point, this honorable court has held that is independent, my lord. The subsequent proposition is absolutely independent. It has been, I'll come to the solution also. Lordship might be having a question in my mind, in your lordship's mind, that what will happen if there is a genuine mistake, what will happen in that case, my lord? I'll just come to that. Now, so far as second proposition is concerned, it has been absolutely settled that there is no provision in the Assam Disciplinary Service Rule, Rule 9 specifically, for holding de novo. It's settled, my lord.
By
Now,
judgment.
I'll just refer the two paragraphs, one of Moloy Bora and Biddut Borgohai. If my lord takes up, now your lordship here will have to appreciate one aspect. This honorable court as well as the Supreme Court has held, irrespective of fact whether the inquiry report is there or, because there is other mechanism available for the disciplinary authority. If an inquiry report is not up to the mark or there is any infirmity in the inquiry report, the disciplinary authority has got the power to issue disagreement note. He can disagree with the finding of the inquiry officer.
Then
That is, my lord, alternative available with.
question is, if there is an what's the purpose of the inquiry? Get to the truth of the allegation.
Correct, correct.
So in order to maintain impartiality, there is an independent inquiry officer, presenting officer.
Absolutely correct.
The allegation is given, witnesses, list of documents, proceeding also. That proceeding arrives at a conclusion that charges proof, not proof, partially.
Correct, my lord.
And these are placed for the
Disciplinary.
disciplinary authority will now have to decide that whether on these charges being not partially proved, whether any punishment has is required to be imposed. So in a given case, all charges may be held to be not proved. In a given case, partially proved, partially not. Some may be proved, some may not be. So disciplinary authority, again, on going through the material reports which are placed, include the report, the statements, whatever it is, may have the option to disagree on certain grounds. That you have held this man, his charge is not proved, but these are the findings, it is. In that case, notice to the delinquent that we disagree and propose proceed. More often than not, disciplinary authority will accept the finding more or less with very minor modification. And then you go in a bit. But disagreement note given will not entitle the disciplinary authority to go for a fresh inquiry.
Yes. So,
Therefore, when there is an inherent defect in the inquiry, are the authorities so helpless to correct it?
yes,
Procedure.
yes, I'm answering that.
Because the principally prejudice, there should not be any prejudice caused to the delinquent.
Not principle is
Then
of
by-
many kind.
Even by following a wrong see, it may be that the findings are in favor of the delinquent, but the procedure prescribed was not followed. And the natural justice or gratuities has to be judged from both sides.
If I may answer just immediately on this point, my lord. If an inquiry is held, but procedure prescribed is not followed, in that event also, the disciplinary authority has got the option to go for further inquiry. That is available, that option. That's why in Molloy Bora, I'm not,
Further inquiry is when they find that that particular charge or these two particular charges somehow certain things were left out.
no, in further inquiry, you can re-examine the already examined witnesses also.
Again, but further inquiry and de novo inquiry are two
Yes, that's why. That's why, Milo, there is this judgment, this honorable court has repeatedly held that there is, because once you go for de novo, your entire evidence goes, the previous thing goes. That is the difference between de novo and further. Whatever evidence was collected previously, that everything wipes out and it's a fresh. So that's why in Molloy Bora, Lord, consciously this honorable court had held that we are not going to educate the department. The options, I'll just read the relevant paragraphs of Molloy Bora.
Yeah.
Class 16, my lord. Or my lord will come from para 15. Lordship Scott, my lord. The law relating to holding a fresh inquiry on the same set of charges after discarding or ignoring the previous inquiry is well settled. A constitutional bench of this honorable Supreme Court in case of so and so, while dealing with provisions of Rule 15 of the Central Civil Service Classification, Control and Appeal Rules 1957, which deals with imposition of penalty on government servant after holding an inquiry, and which provides for holding further inquiry if the situation warrants, held that Rule 15 therefore does not contemplate holding of fresh inquiry on the ground that the earlier inquiry was not proper or did not appeal to the disciplinary authority. In the facts of that case, the apex court observed that collector, instead of taking responsibility himself, was determined to get some officer to report against the appellant. The procedure adopted was not only unwarranted but by the rules, but was harassing to the appellant. In Union of India versus
just 1 minute here.
Yes.
Here, what happened? He did not file WS. What happened here?
No, my lord. What they have done, initially they have issued a show cause notice. Along with this,
without list of documents
Without-
and list of
along with the show cause notice, they did not enclose the list of documents, list of witnesses. I told them that.
And the inquiry procedure.
Inquiry proceeded. I informed them.
Complete-
Inquiry proceeded.
completed.
Yes. Then inquiry officer submitted report.
it was
After that, inquiry officer submitted report. After, and the first inquiry report, which was submitted by the inquiry officer, it was as good as exonerating me from the charges. By saying here and there something, my lord, lastly he said that the
Not-
charges are proved. But it is as good as, my lord,
Charges are proved or not proved?
prove. There is no content in the, it's a one-page inquiry report. There was no content in the inquiry report. By saying here and there something, my lord, he finally said that charge is proved. So it is as good as exonerating me from the charges. Then after 4 years, they continued with that. Then after 4 years, they, my lord, woke up and they decided that we'll go for de novo inquiry. Now, factually, my lord, I'll just apprise your lordship. This will be my second argument. May I just complete this, my lord?
Yes, yes.
Yes. In Union of India versus KD Pandey, 2002-10 SSC 471, the apex court drew a distinction between a second inquiry and a further inquiry on the same set of charges and materials on record. It was held that the second inquiry was not permissible, and if such a process is allowed, the inquiries can go on perpetually until the view of the inquiry authority is in accord with that of the disciplinary authority, and it would be an abuse of process of law. Similar view has been taken by the apex court in recent decision reported in so and so. It has been held that non-acceptability of the inquiry report submitted by the inquiry officer cannot be a ground for rejecting the inquiry report and ordering second inquiry. In Bidyut Borgohai versus State of Assam, this court was examining the provisions of Rule 9 of Assam Service Discipline Appeal Rules 1964, more particularly Rule 99 thereof. It has been held that there is no specific power under Rule 9 empowering the disciplinary authority to hold a fresh de novo inquiry in case the disciplinary authority is in disagreement with the finding of the inquiry officer. The rules are conspicuously silent in this regard, and no such power has been specifically or impliedly conferred. The comparison of the provisions of Rule 15.9 of the CCA Rule 1957 and Rule 9.9 of Assam Service Disciplinary Appeal Rules 1964, it was held that the two provisions are in perimeteria. While a further inquiry may be permissible by directing the inquiry officer to examine further witnesses, a fresh inquiry into the same set of allegations by discarding the earlier inquiry report is not contemplated. No specific power to hold a second inquiry into the same set of allegations which were earlier inquired into have been vested with the disciplinary authority under Rule 9 of Assam Service Disciplinary Appeal Rules 1964. Now, this is the proposition of law that has been decided by this court. Further, the provisions of Rule 9 of the Assam Service Disciplinary Appeal Rules 1964 have been held to be a mandatory provision. In later judgment in case of so and so, this court referred to decisions of Bidyut Buragohai as well as para 6.1 18.1 of the manual of the departmental proceeding. After quoting the said paragraph from the manual of the departmental proceeding, this court held that the said provision would be applicable only when disciplinary authority finds that any material irregularity has been committed and the same might cause prejudice to the person charged, or such irregularity is likely to vitiate the departmental proceeding. Thus, the said provision is intended to remove any prejudice caused to the government servant against whom the departmental proceeding is initiated. This line is important. However, even otherwise, it has been held that the said provision cannot be used to override the mandatory provision of Rule 9 of Assam Service Disciplinary Appeal Rules 1964. So this provision, my lord, 6.18.1 is for the benefit of the charged officer. It is not an instrument for the disciplinary authority to get to a desired result or cure defect in the departmental proceeding. Because Lordship will appreciate, my lord.
So essentially what you're saying
Lord,
is
Lordship will appreciate one
the
thing.
garb of correction.
Exactly.
They had virtually they had discarded the inquiry report because it was in a sense in favor of the delinquent.
What they have done is more interesting. They issued a show cause notice, which did not contain list of dates and list of documents. Lord, you are holding a major penalty proceeding against a government servant, Group A officer. Forget about the allegations, whatever be the allegation. Only, is it not your responsibility to draw up a proper charge sheet? It is because major penalty proceeding is as good as a conviction in a criminal proceeding, my lord. He will lose his job and he will lose his livelihood. Is it not your responsibility that you draw up at least a charge with list of documents and list of witnesses? Fine. You may be confident that without even list of documents and witnesses, you can prove the allegations. Very well.
That's
I indicate.
relied on.
Sorry, Milo.
Those were relied upon.
Sorry, Milo.
List of the witnesses and documents were relied upon in the proceeding, or not relied upon.
No, in that inquiry, my lord, the inquiry officer, my lord, call the petitioner, call another witness, take their statements and derive conclusion.
One day.
One day. So, what That's why I said that that enquiry report is as good as exonerating me from the charges. You want to distinguish it saying that if the enquiry report is in favor, then only the law will come. That is not the proposition of law that has been decided. Even if in that enquiry report charges were proved, that is as good as exonerating me from the charges. Now, that enquiry goes, I intimated you. Look, you have not included list of documents and witnesses. Despite that, you proceeded with the enquiry. Enquiry officer proved the charges. I submitted reply. Then after 4 years, you somehow woke up. Then you decided, no. We'll go for de novo enquiry. Now, Lordship will kindly appreciate one aspect. This, even assuming for a moment that de novo inquiry is permissible in the eye of law, assuming the decision taken was to go for de novo inquiry, not to go for de novo departmental proceeding. Lordship will appreciate the second show cause notice issued by the inquiry officer is violative of their own decision. If the decision is with regard to de novo inquiry, you could not have issued a fresh show cause because it was, what was the decision? Even assuming for a moment de novo inquiry is permissible. The decision was that there were some infirmity in the inquiry, so we will go for a de novo inquiry. We will wipe out the entire earlier evidence and we will go for a de novo fresh inquiry. That was the decision of the disciplinary authority. But the fallacy that was done by the inquiry officer,
Yes.
she issued a show cause, fresh show cause notice, my lord. Where is the decision to issue fresh show cause notice? So the show cause notice, basing on which the penalty of dismissal from service was imposed upon the petitioner, that itself is contradictory to the decision of the disciplinary authority. That is my second plank of argument. Even assuming that, my lord, de novo can be gone into.
Yes.
So, in Molloy Bora or Honorable Apex Court judgments, my lord, which, my lord, relevant paragraph I have read, it specifically provides that there is no provision in the rule. Because as a disciplinary authority, you also don't have that laxity to become casual. You are also required to be serious, my lord. So you will go on committing mistakes after mistakes and you will try to cure it. My lord, that is not the mandate of 6.18.1.
All right. We'll resume again.
Yes.
I'll just from your lordship, items 17 and 18, if not inconvenient, can it be taken up on 17? 17 June.
We don't know. We can't fix a date like this. Huh? 17 and 18.
Yes.
Once it is fixed, it's difficult to again refix it. Unless
That is why I prayed, my lord, if lordship not inconvenient.
Let it be in July. Is there any urgency?
There was an urgency, but if lordship please not, if not inconvenient on 17, there is another matter also here in this.
We do not know what is on there on 17, 18.
Or any day.
Let it be in July. Immediately after reopening. 17, 18. We'll list it in July. The request made by Council for the
May pray for a date, my lord, if not.
have it on 17 July.
Yes, yes. Blood.
Yes.
Wait, please, Lord. But I was in the
was about to complete the last paragraph, second last paragraph, in fact, para 21 of Molloy Bora. Para 21. Good. Yes. Therefore, from the above, it is crystal clear that the inquiry officer had gone into the basic allegation against the petitioner and thereafter gave his finding. If the findings are not acceptable to the disciplinary authority, the latter is not powerless to meet the situation. The law on this point is quite clear. However, it is not for the court to suggest the course of action to be taken by the disciplinary authority in such a situation. But holding a de novo stroke fresh inquiry on the same set of charges on the ground that the previous inquiry report is not acceptable to the disciplinary authority is not permissible and is contrary to the law laid down by the apex court. So these two, Molloy Bora and Bidut Borgohain, lays down two propositions of law. One, in the given facts. Second, that there is no provision for de novo. And while referring to these two judgments, I have shown just before the lunch, my lord, the type of illegality that had occurred in this matter. Because their own decision, even I, for a moment, I admit, yes, they have got the power to hold a de novo. Their action is contradictory to their own decision. Because there was never a decision to hold a de novo DP. If I take your lordships to the notification by which decision was taken to hold a de novo inquiry, that my lord will find page 124.
Hmm. 124
124 of WPC 6452.
Yes.
So, original DP was initiated in the year 2016. And in 2020, they took third paragraph, my lord. Whereas the governor of Assam considers that a de novo inquiry is needed to be initiated and an inquiry officer should be appointed to inquire into the charges framed against Sri so-and-so. Now, therefore, the governor of Assam, in exercise of powers conferred by Sub-Rule 4 of Rule 9 of Assam Service Disciplinary Appeal Rules, hereby appoints Sri so-and-so Aloka Goswami, ACS, Additional Secretary to the Government of Assam, Excise Department, as inquiry officer to inquire into the charges framed against Sri so-and-so. Now, third paragraph, what was the decision? De novo inquiry. Even assuming that de novo is permissible, you decided that the entire inquiry will do it fresh.
Subsequently, are there new charges?
No.
Same charges.
Same charges.
But according to you, separate show cause.
Separate show cause. So where is the?
You also reply to that.
Yes, I have to reply. So where is the? When there is a decision, this is I am arguing against myself, my lord.
That would be a very technical view to say that merely because a show cause notice is issued, then it has to be construed to be a de novo disciplinary proceeding. That is your argument.
So
But essentially, the charges are the same.
charges, look, actually, Milord, if I see in a proper perspective the entire thing, you have issued a charge sheet. It is expected, being a disciplinary authority or being a state, you will have to do justice in proving the allegations also, Milord. It's not that you will just throw some papers, throw some charges. In any manner, you will hold the charges to be proved and impose a penalty. In 2016, you issued a show cause notice. If you don't want list of documents, list of witnesses, it is your call. Charges were framed. I replied, look, your charge sheet doesn't contain list of documents, list of witnesses. That aspect is there. You did not take a call at that point of time. If you were so serious on this issue, then you immediately, the remedy was available to you. Even at the time of deciding that 2020, that will go for de novo inquiry, if you were really aggrieved that you somehow, Milord, issue a faulty charge sheet, the option is always available to you, being a state, that you drop the proceeding, draw up a fresh. The entire earlier DP goes, his suspension goes, reinstatement comes, and you give a fresh charge sheet. You did not do that. What you have done, you took a decision in 2020, no. We'll go for de novo. In fact, the de novo inquiry order, it also doesn't contain any reason, my lord, why they want to go for de novo. Now, you take decision that will go for de novo, but you act which culminate into going for it.
That aspect, I don't think it will. You have argued, we'll record it. That's not a, but
yes,
we don't want to go into this aspect that it is not a de novo inquiry, but a de novo proceeding.
That, my lord, this subsequent argument is I am arguing against myself, my lord, because my proposition before your lordship.
Because you're not prejudiced, otherwise.
No,
you're not prejudiced in terms of the fact that notice some new charges were leveled against you. You're not
it's
given.
not a case of prejudice, my lord. The law with regard to prejudice is that when there is a violation of procedural provisions,
That's right.
prejudice is automatic.
That's what I'm saying. So your the prejudice which you are facing is the fact that there is no procedure, there is no provision for de novo inquiry.
Exactly.
Say that no, it is not only a de novo inquiry, it's a de novo disciplinary proceeding.
That is, I am arguing against myself, my lord. Even assuming that there is a power for de novo, just to clarify the position, then also you have committed a mistake, my lord. You have committed a wrong. That is what I try to place before your lordship. But my main plank of argument is that, my lord, Maloy Bora and Bidyut Borgohai is absolutely quite clear on that second proposition of law, that there is no provision. So that proposition of law is final. Now your lordships essentially asked me a question at the very beginning, that what will happen if in the inquiry there is some infirmity, procedural infirmity, then what are the remedies? The remedies are disagreement note, further inquiry. But there is no remedy of de novo. There is no, one judgment has been placed, my lord, I'll distinguish that judgment of my lord Justice Surana. So there is no de novo. You can go for further inquiry, you can go for disagreement note. In Maloy Bora, that has been said. And in Bidyut Borgohai also. But you cannot wipe out the evidence. There is another flaw here, my lord. It will amount to, once I participate in the DP, whatever defense I have, I expose all the defense before you. Thereafter, you take a call, after all my defense are exposed, that is prejudicial, man. It will cause serious, because you continue to go on.
That is on the ground that subsequent disciplinary proceedings are correct. that is on the ground that subsequent disciplinary proceedings are correct. Now, de novo inquiry, whether it is permissible, not permissible,
That is settled already.
question. We'll
Yes.
decide on that. Assuming it is permissible, or let us say that argument which you are making that you have disclosed your defense and therefore it is prejudicial, will also prevent further inquiry. If that is the argument, if we have to accept, then the authorities cannot even go for further inquiry.
No. Here, my lord, in de novo, you can wipe out. The entire things will go. But in further inquiry, my things will remain. From the records of the inquiry, that means, my lord, if I have to file a case after the inquiry or DP before the honorable court,
What is your the procedurally you are submitting that yes, de novo is not provided, these are the judgments
lordship will confine to that.
to that. If you're proceeding into the area of prejudice because your defense
No,
was
prejudice I'll come.
Huh.
Prejudice, my lord,
your argument is that you are prejudiced because it is a violation of the procedure.
my lord, I am not even arguing prejudice. My argument is not based on prejudice. My argument is
It has to be because you are
no, not in every case, my lord. Not my
you
lord,
are questioning the procedure.
my argument is that if there is if a power is not conferred to you in the given set of rules, then how can you my lord, exercise an alien power to pass an erroneous or illegal order? That is prejudice, my lord. So far as the concept of prejudice is concerned, it's the law. I am not required. It's not a, my lord. It's
You are
not a.
required to prove.
Yes.
If the procedure prescribed is not followed.
If the procedure prescribed is not followed, then the prejudice is automatic.
Right.
Line of judgments are there, you know.
Yes, yes.
So I need not required to prove what the prejudice is. Now, first is that second argument I have already made what wrong they have done, even arguing against myself that de novo is permissible. Then also they committed a mistake. They could not have issued a fresh show cause notice. That too by an inquiry officer. First order, Oloka Goswami appointed as inquiry officer. And same inquiry officer issued a show cause notice. Now, if I come to the evidence portion, your lordship will see if your lordships kindly
These we have already argued. Now you are in
No,
the
no.
rejoinder.
I'm on. I'm not. I'll be as brief as I can. Lord. They wanted to prove the charge wherein the complainant was not made a witness. In both the show cause notice, the complainant, who was PP Fukon, he was never made a witness. So who will come? Because lordship will appreciate. Ultimately, in the inquiry officer had held that demand was not proved, acceptance was proved. That was the finding of the inquiry officer. So someone has to come, or there has to be independent witness who had seen.
This argument will come when you are challenging the first inquiry procedure.
No, here I am challenging the penalty order. So perversity is also one of the grounds that I have urged in the writ petition to challenge the penalty order. This portion of argument goes to the aspect of perversity, that there was no relevant evidence before the inquiry officer to come to the conclusion that the charges were proved.
We are not even required to go into that.
So even
only if we hold that de novo inquiry is permissible.
It's
That's
not,
the fact.
Miller, but my submission is that, Miller, if the merits of but my challenge is to be decided, then, my lord, this is also there can be many grounds to challenge a decision, my lord.
So
So-
you can add as many grounds as you want. but
Yes.
We have to we have to decide. We are not sitting
Lordship-
here as an appellate authority to look into all the
No, these are
evidences,
fact.
how
my lord,
relevant, how irrelevant.
No, these are not.
We have to see whether the procedure prescribed and as you say it's not prescribed is sustainable the proceeding and consequently all the subsequent orders. Assuming the procedure prescribed is sustainable, then we'll have to see what extent the disagreement note and other consequential orders are required. That get put on our without even finding details to all these.
No, lordships can always go to the perversity, my lord. My lord, because that is the core of a challenge in any DP, my lord. Perversity, your lordships, Mani Shankar, my lord, Honorable Supreme Court has held that if a ground of perversity is urged, whether the conclusion was based on relevant evidence or irrelevant evidence, that the court can go into. My lord, I'll just one paragraph of Mani Shankar, my lord. It was
We are not even remotely questioning whether the court has the power to go into purpose.
yes, my lord.
We are saying that since you are questioning the very procedure
Yes,
in view of the settled law, it is only after that the further
yes,
issues about perversity, relevancy,
Those will
etc.,
come.
etc., come.
either my lord can take one by one or lordship can take up entirety
We are
because
taking
I'm
up entirely because this is the
Yes.
first time the hearing.
yes. So
But-
that's
Your challenge primarily is on the ground that the procedure is not valid.
all my grounds are primary, my lord.
No,
For the
because I'm saying
yes, my lord.
the first order to be sustained, the first inquiry report, it will be sustained with, according to you, if read, the conclusion will be that it is in your favor.
Your lordship can have a look. Yes,
So, vis-a-vis that, whether a disciplinary authority would have had a disagreement note on the materials available. That is the parameters of perversity, so far as you are concerned. This is why you are urging perversity.
no, my lord. Lord, my lord, my perversity, the perversity that I am arguing before your lordships is that because the inquiry officer has to derive conclusion on the basis of some relevant evidence.
That's what I'm saying. So, from the inquiry report,
Even the second,
even the second will come only if we hold that the procedure is correct.
your lordship is absolutely correct, my lord. There is no
Oh.
doubt about it.
So there is no point in arguing academic questions.
No.
You confine yourself to the issues which are here
Yes.
so that we can deliver a judgment.
Yes, my lord. So far as, my lord, regarding de novo is concerned, this is my issue. And so far as perversity is concerned, I have already on the last occasion, at my beginning, I have given judgments also that how the decision of the inquiry officer was perverse. Because there was no evidence, the complainant did not come and all those things are not there. He relied on a police report. That police report was not even a part of the list of documents in the charge sheet. Or that police report was not produced before the during the course of the inquiry. So those were my total grounds leading to the argument of perversity. Now, one lordship will kindly note down two paragraphs, para 50 and 51 of the writ petition. This is my proposition with regard to, my lord, acceptance, demand and acceptance. Because acceptance will not only lead to the proof of the charge, there has to be a demand. So para 50 and 51, I developed a proposition that without a demand, the allegation of illegal gratification could not have been proved. There is a judgment also of this Honorable Court, recent judgment, although it's with regard to, my lord, PC Act, but the proposition of law that a standard of proof may be different. There the standard of proof is proof beyond reasonable doubt. Here, preponderance of probability. But the proposition of law that has been held by this honorable court is that acceptance will not alone will come to derive conclusion that the person has taken illegal gratification. A clear demand has to be there. Now, in the present facts, all along since the application for bail, my contention is that the money was thrust upon me. The enquiry officer also, in his conclusion, recorded that I did not demand money. There is no evidence. In fact, the witness, he also came and deposed that there was no demand of money. It was only acceptance. So I'll just give the citation. Lordship will not look into the judgment from the point of view that it is a criminal court judgment or it's a matter in the PC Act. Lordship will kindly appreciate this.
You give your judgments, we'll look into it. But
yes,
essentially, your ground is that when the basic allegation, the person who made the allegation is not even examined.
Exactly.
On what basis have you come to a conclusion that money was demanded?
Exactly. That is.
What is the judgment?
This is, my lord, 2025 1 GLT 475. Debeshwar Talukdar versus State of Assam. The relevant paragraphs are, my lord, 60, 62, and 63. So this is purely on the basis of proposition that whether you can, in PC Act, the standard of proof may be different, but the law, the legal proposition will always remain. That is, acceptance alone will not lead to the conclusion of proof of the charge of illegal gratification. Now, another judgment, I'll just place it before your lordships. It will be. On the same point, my lord, admission of receipt of amount cannot be said to be admission of misappropriation that is required to be proved by adducing evidence and tested by cross-examination. 2016 4 GLT 277. Relevant paragraphs will be 28, 29, and 33. Here, the delinquent charge officer admitted that I have accepted.
What are the paragraphs?
28, 29, and 33. Just one paragraph I'll just place before your lordship. Small paragraph. I'm just reading, my lord. Lordship need not need to look. Para 33. Reverting back to the impugn order, it is evident that the petitioner had only admitted receipt of rupees 2 lakhs from Minority Development Corporation and rupees 5 lakhs as grant from 12 Finance Commission. Admission of receipt of the aforesaid amount by no stretch of imagination can be said to be admission of misappropriation. The charge framed against the petitioner was required to be proved by adducing evidence, which was required to be tested by way of cross-examination. Suspicion stroke presumption cannot take the place of proof even in a domestic inquiry as held by Narendra. So here, my lord, when you don't have any material to derive conclusion of demand, that means on the basis of acceptance, it is only a suspicion. You suspected that he has demanded and accepted money, but demand was not proved.
What are the facts here?
Here, my lord, I'll just place the facts. My lord. Para 2, by filing the writ petition under 226 of the Constitution, petitioner seeking passing of order dated so and so, passed by the Director of Secondary Education Assam, imposing penalty of recovery of rupees so and so from the petitioner 3,000 per month after his superannuation. Substantive post of the petitioner was so and so, so and so. By the order dated so and so issued by the Director of Secondary Education Assam, petitioner was placed under suspension with immediate effect. It was mentioned that a report was received from respondent number 6 as President of the School Managing Committee and Development Committee alleging misappropriation of government grant to the school amounting to rupees 7 lakhs for the purpose of infrastructure development. On 2011-2012, show cause notice was issued to the issued by the Director of Secondary Education as disciplinary authority to the petitioner under Rule 9. The allegations were that while you were principal, you may misappropriated of government money sanction amounting to rupees 2 lakh from the Minority Development Corporation and 5 lakhs construction of classroom school building grant under 12 Finance Commission. Then petitioner submitted reply. Then impugn order was issued imposing penalty.
Yeah.
Then plea of alternative remedy was addressed. Then this honorable court has done, that is discretionary in nature, may file, may not file. Para 28, your lordship will have some facts, my lord. Coming back to the impugn order dated so and so, it is seen that the disciplinary authority himself conducted the inquiry. He had recorded statement of the petitioner and heard the president of the School Managing Committee and Development Committee, i.e. respondent number 6. It is also seen that the technical member of the School Management and Development Committee had submitted a report to the Inspector of School Kamrup showing misappropriation by the petitioner to the tune of rupees 1.76 lakh. The disciplinary authority specifically stated that having regard to the statement of respondent number 6, petitioner and the report of the technical member of the School Management and Development Committee, he was satisfied that the charge of misappropriation of money by the petitioner to the tune of rupees 1.76 lakh was proved. From the above, it is evident that the respondent number 6 had given evidence in the inquiry against the petitioner. Not only that, the report of the technical member of the School Management and Development Committee was taken into consideration by the disciplinary authority acting as an inquiry officer. In the absence of any list of documents and witnesses giving prior notice to the petitioner that the respondent number 6 would depose in the inquiry and the report of the technical member would be taken into consideration, such action of the disciplinary authority clearly amounted to violation of the principle of material justice, thereby vitiating the penalty imposed. As per Rule 9(6) of Rule 64, charged government servant has the right to cross-examine witnesses, examine in support of the charge, and give evidence in person in addition to adducing documentary and oral evidence in his defense. Material on record do not disclose that the petitioner was allowed to cross-examine the respondent number 6 in the course of inquiry and that a copy of the report of the technical member was furnished to him. So these were the background facts on which. So here in this matter, my lord, the person who complained, he came and deposed.
All right.
But in our case, my lord, I was completely given no opportunity to cross-examine the complainant. He was, my lord, he was kept out of the purview of the inquiry. If you want to prove that whether I demanded and accepted the money, he was the only person who could have deposed before you and produce evidence against me that I accepted. So there was no material.
All right. Anything more?
One more submission, my lord. This is also, they took advice of the APSC before imposing penalty, and Rule 11A of the Assam Service Discipline Appeal Rules, Rule 9A,
Disciplinary.
Here, my argument will be, my lord, advice of the APSC was taken. That advice was never communicated to me prior to imposing the penalty. As per Rule 9A, as per Rule 9A, prior to imposing penalty, I am entitled to get a copy of the advice of the commission. Order made by the disciplinary authority shall be communicated to the government servant, who shall also be supplied with a copy of the report of the inquiry, if any, held by the disciplinary authority, and a copy of its finding on each charge, or where the disciplinary authority is not the inquiry authority, a copy of the report of the inquiring authority and a statement of findings of the disciplinary authority, together with brief reasons of its disagreement, if any, with the finding of the inquiry authority, unless they have already been supplied to him. And also, my lord, this is important, and also a copy of the advice, if any, given by the commission, and where the disciplinary authority has not accepted the commission, a brief statement of the reasons for such non-acceptance. So, it clearly provides that the copy of the advice of the commission is also to be furnished to the charged officer, which has not been done here, my lord. And in support of that, my lord, the provision of UPSC is, my lord, akin to this. In CCS, CCA, UPSC's advice, there is one judgment, my lord, Union of India versus RP Singh. There are 12, 13, 14, and 23.
Can you come back to the provision again?
Yes, my lord. 9A. Communication of orders. Orders made by the disciplinary authority shall be communicated to the government servant, who shall also be supplied with a copy of the report of the inquiry, if any, held by the disciplinary authority, and a copy of its finding on each charge, or where the disciplinary authority is not the inquiry authority, a copy of the report of the inquiry authority and a statement of the findings of the disciplinary authority, together with brief reasons of its disagreement, if any, with the findings of the inquiry authority, and also, my lord, and also a copy of the advice, if any, given by the commission, and where disciplinary authority has not accepted the advice of the commission, a brief statement of the reasons for such acceptance. So, orders made by the disciplinary authority shall be communicated. First is that, my lord, inquiry report. Second is the disagreement note, and third is, and also a copy of the advice, if any, given by the commission. The commission advice is also to be given, and where disciplinary authority has not accepted the advice of the commission, a brief statement of the reasons for such non-acceptance has to be included. So commission's advice has to be communicated. This 9A came by virtue of an amendment.
Yes.
So this was not done, which vitiated, in my humble submission, the inquiry. RP Singh, my lord, I am relying on. It is in the context of, my lord, UPSC's advice by the central government, but the proposition of law that has been laid down at para 12, 13, 14, and 23.
Paragraphs
12, 13, 14, and 23, my lord. If I just read 4 lines from paragraph 23, my lord. Advice from UPSC, needless to say, when utilized as a material against the delinquent officer, it should be supplied in advance. As it seems to us, Rule 32 provides for supply of copy of advice to the government servant at the time of making an order. The said stage was in prevalence before the decision of the Constitution Bench. After the said decision, in our considered opinion, the authority should have clarified the rule regarding the development in the service jurisprudence. So it is quite settled. Now, in the last paragraph, my lordship will also record para 27, my lord. In view of the aforesaid,
after the first inquiry, there was no order passed by the disciplinary authority. It remained in cold storage.
it remained in cold storage for 4 years. Then 2020, they woke up. And my last proposition would be, my lord, on proportionality. Recently, there's a recent judgment by the Honorable Apex Court, my lord. This is General Manager Personnel versus Personnel Syndicate Bank versus BSN Prasad. This is on proportionality. Proportionally. Lordship, why I am urging this, my lord? Lordship will kindly appreciate. This person has served his entire life for the department. It was a solitary incident in his entire service career. There was no previous incident of any misconduct, misbehavior, or any illegal act. So this solitary incident proves the proof of the charges that your lordship has already seen. What type of proof came out during the course of the inquiry. And after that, they have imposed penalty of dismissal from service.
Yeah.
So in that context, my lord, my humble submission is that, my lord, the penalty imposed is grossly disproportionate. Para 23 and 24. There are 23 and 24. Just 4 lines from 24 minutes. The respondent was employed in the appellant bank on so and so, and he had an unblemished service for more than 21 years till 11 June 2007. We have perused the Syndicate Bank Employees Disciplinary Appeal Rules 1976. Under Regulation 4, there is a provision for imposing minor penalty and major penalty. The respondent has already reached the age of superannuation. In our view, the penalty of dismissal was disproportionate to the misconduct established against the respondent and his unblemished career for a long time. However, fact remains that the misconduct alleged and proved against the respondent was of a serious nature. Considering the fact that a very high standard of conduct is expected from branch manager of a bank, considering the fact that considering the facts of the case, we are of the view that a minor penalty, as provided in Regulation 4E of the Disciplinary Regulation, would be appropriate. The penalty will be of reducing the respondent to a lower stage in the time scale of pay for a period of 1 year without cumulative effect, and not adversely affecting his pension. So taking into consideration the long unblemished service, now it cannot be my fault that you have continued with the DP for 10 years. I always wanted the DP to be concluded early. There was no delay on my part in submitting replies and all these things. But you continued with the DP, and this was the only charge in my entire service career I faced. Nothing else. I was a topper in APSC list, although that is not relevant. APSC selection, I was a topper, number 1. So, in my humble submission, my lord, one more submission, my lord. My senior referred to one judgment, Abdul. If you're Abdul Adut Mullah, wherein my lord Justice Surana derived conclusion that it's not absolute bar. So in that judgment, if your lordships kindly consider distinguishable in the present fact, because in that judgment, the petitioner made a request before the inquiry officer that the inquiry was flawed and he wanted a de novo. And only to protect him, as has been said in Bidut Borgohai, that 6.18.1 comes into play to save an officer from causing prejudice.
Yeah.
So our case is factually distinguishable. In that case, the petitioner requested, he submitted a representation saying that go for a de novo. Here, my lord, that did not happen. They even after my saying, look, your thing did not contain this thing, they continued. That means it's a tacit approval that now whatever is there, we'll go with it and we'll hold the charges to be proved or not proved. We'll conduct an inquiry against you. So this is precisely my submission before your lordships, my lord. I think the petitioner will be retiring. Okay. In the month of September, my lord. What is it? No. He'll attain the age of superannuation in September this year. So retirement age there how is it?
Yes.
In my humble submission, my lord, the penalty of dismissal from service imposed upon the petitioner is unsustainable in law, my lord. He is entitled for reinstatement in service with all consequential benefit with full back wages, my lord. My lord, for back wages also, I have got a judgment, my lord. It provides that if a termination order is illegal or dismissal order is illegal, then the person concerned was kept out of service without his wish. So in that event, he is entitled for full pay and allowances. My lord. The citation is, my lord, it's by Justice Nariman. 2006.
There's a judgment of this court also,
Yes, yes, there is
division bench judgment.
exactly, my lord. The division bench judgment is also there. I got hold of this one, my lord. This is 2016, 16 SCC 663.
Six,
663. So if the penalty goes,
what is the party name?
sorry, my lord.
Name of the party?
Sobha Ram Rathuri versus Haryana Vidyut Prakashan Nigam Limited.
What are the paragraphs?
Paragraphs would be, my lord, para 3. Small judgment, my lord, 2 page. It says, after the penalty order, the fault lies with the respondents in not having utilized his service. So it's not the fault of the person concerned. My humble submission, my lord, this writ petition deserves to be allowed, my lord, granting appropriate relief to the petitioner. So far as other two writ petitions are concerned, those are with regard to promotion of this person. Once this is decided, my lord, fate of the other two will, my lord, follow this writ petition's decision, my lord. So those two, my lord,
What are the other two?
promotion matter, my lord. Long back, there was a promotion dispute.
While you were in suspension.
No, while I was in service, some juniors superseded me without any reason. Against that, I approached. So if this comes in my favor, then only those.
Why are you connect? These are issues are different entirely.
This is not.
Why are you?
No, why connected, my lord? That
Assuming
if my
if your writ petition is dismissed,
nothing remains.
actually those will be dismissed.
Yes,
But for which a separate order can always be passed.
that's true.
Now, if we have to club it together, we
That's
have to discuss on the facts of that case.
No, not
See,
required, in fact, my lord. If your lordship fix those matter in another date,
We'll segregate it.
fine, my lord.
We'll segregate it.
No problem in that.
Yes, Mr. Swami, we close it.
I
Heard,
My last
Mr.
submission is the petitioner has failed to make out any case for invoking jurisdiction of this honorable under 226 of the custom. So hence it is liable to be dismissed. That is the first.
We'll have it on 12 for orders.
Well.
Heard Mr. H.K. Das, counsel, the petitioner, Mr. P. Goswami, additional AG, hearing for the state, the councils have made their submissions before the court. For further submissions, if any, on 12. Please sit on 12.
For judgment.
We are keeping it for hearing only. We'll deliver the judgment.
Well.
Note there, Sapdani kar. And in respect of the other two writ petitions, we are
Lordship will segregate it.
which are the items?
Item number 12 and 13, madam.
So you write item 11 on 12. Huh?
Yes, 11 and 14 on 12.
11 and 14 on 12.
Yes.
And 12 and 13, you
Will
write
be
that
some other.
it is in view of the submissions made that these writ petitions pertain to the challenge made by the petitioner for non-consideration of his case for promotion.
Yes.
These two writ petitions are segregated from item 11 and 14 to be listed separately.
Ma'am.
After 2 weeks.
Can it be after the vacation, madam?
All right, after the vacation.
Yes, ma'am.
After the vacation. Please take out it.
Much obliged, ma'am. Deeply obliged for the
I'm
patient.
grateful to you. My lord, whether the record will be if necessary, I
record of proceedings.
yes, proceeding and the process initiated as reflected in the record. Lordship, I have shown the record
You keep it with yourself.
Yes.
If we require, we'll request to the court master that the records be sent.
Obliged.
Otherwise, you retain the record.
Well,
Obliged.
much obliged.
Yes. Yes.
May it please your lordship. Lordship, this matter is regarding discharge of the petitioner.
We are not
imposing-
proceeding with the hearing today. We'll fix it for some other day because we have to write out some judgments also. Right? So,
Well,
Will-
can it be possible next week? Possible.
not next. We'll take it up after we get
Lordship, any fixed date?
fixed date. You can have this matter. Yeah. As matter will have to be heard. Yes. As the matter will require putting hearing. Let this matter be considered again. So, 22nd of July.
Well,
Sorry, 21st of 22nd of July.
22nd.
Second.
Deep level.
Lordship, my senior Mr. SK is out of station. That may be passed for.
Yes.
No, that's not-
The request made on behalf of the learner CTC matter sent passed over for the day. Please accordingly. MS so and so appears for the petition.
Really?
Yes. Yes.
But here in this matter, my lord, the department was directed to produce some
C.
record.
Sharma.
Yes.
Where is Mr. C. Sharma?
I am appearing for Social Justice Department.
You are appearing.
Yes, your lord.
Social welfare and empowerment.
Yes, Social Justice.
Yeah.
Lordship, we have received the relevant documents which shows that there is already 2 vice chairmen are working in the working for the community, your lordship. Since there is a mistake on the part of the government that in spite of the there are already 2 vice chairmen, the petitioners are been appointed, your lordship.
No. With the petitioner, there are 3 vice chairmen.
Yes, your lordship.
3.
3 years, lordship. That is why, lordship, other 2 are working from 2022 and 21, your lordship. I have
Then-
the documents, your lordship.
Bring it on record. You
But
bring it
I
on
didn't
record
see.
so that he can
Yes,
revert
sir.
to it if required. MSR Deka, Council representing social welfare and empowerment.
Yes, your lordship. Social Justice and Empowerment Department.
Social Justice and Empowerment Department submits that she has received instructions which shows that besides the petitioner, there are already 2 vice chairmen appointed for the what is that council?
Yes, yes.
What council?
Rajvanshi Development Council.
Post Rajbongsi Development Council. So, the petitioner, after appointment of the petitioner, petitioner is the 3rd vice chairman appointed to the same council. So, under such circumstances, the department passed necessary orders for withdrawal of the order for appointment of the petitioner. She, however, submits that these instructions and relevant documents are required to be brought on record, and for which it is liberty to file an additional affidavit. Prayer not objected to by the council to the petitioner. List again
The 2 is
after 2 weeks.
Only one thing, my lord, this submission has already been recorded earlier, my lord. Kindly, your lordship may kindly peruse the order dated 1/5/2025, my lord. In fact, my lord, the stand taken by the department was totally different, my lord, earlier.
There is a
That's right. We permitted you to produce a relevant record.
yes,
So
your
you have given the
Yes.
document.
Yes.
If you are objecting it, we'll just keep it on record. If you want it to be brought properly on record, then it has to be brought by way of an affidavit. So that you may like to revert or controvert.
Then your lordship may fix a spot date so that can
It is
matter
filed
may be
within
in
2 weeks.
After 2 weeks.
2 weeks.
2 weeks, my lord, it will be holiday, my
After vacation, yeah.
After vacation.
After
It will be after vacation.
lord. Then date may fix a date. My humble prayer, my lord.
Please take it on 3rd of July,
Obliged.
One of 15 people hearing.
15th of July.
Obliged.
This case, my lord, the present petitioner was dismissed from service by impugned order dated last of June 2022. And on being appealed against the said order, my lord, here the order of the impugned 1/6/22 has been upheld by the appellate authority. My lord, agreed with the inaction of the respondent authorities, the present petition approached this honorable court for appropriate relief, considering some irregularities occurred during the course of disciplinary proceeding initiated against him by the disciplinary authority or the inquiry officer. Madam. Your lordship, while adjudicating this matter, on last occasion directed the respondent side to place the relevant record.
You're not filing in.
Found record has been given to me today only, Lord. So I just need 2 days time to go through this, Lord.
How much time? How much time do you
3 days, Lord.
matter be listed again after 1 week? Maybe
Lordship.
Government Council. There is the record
Lord.
that is of the department. Prayer made. Petition is taken after 1 week.
10/6 months. 10/6.
No, after 1 week.
After 1 week.
It's 10 months.
Not 10.
10. 2 days. 3.
After 1 week, not 10. Have it on 13.
Lord.
13.
Obliged.
Deeply obliged.
Yes.
Well, in the gratuity matter, my lord, we have concluded our submission, the argument. Just for refreshing my memory, I would like to submit.
Yeah, light बंद कर दियो. क्या कर? हाँ.
I'd like to submit that I'm relying on section rule 36 of the CCS pension rule.
CCS pension and gratuity. Pension. Yes.
Rule 36
of the CCS.
CCS pension rule. It covers my claim.
Yes.
May I read, my lord? A government servant who has been permitted to be absorbed in a service or post in or under a corporation or company wholly or substantially owned or controlled by the central government or a state government or in or under a body controlled or financed by the central government or a state government shall be deemed to have retired from the service from the date of such absorption, my lord. This is exclusively my case. Then if I may take your lordship to sub-rule 2, the absorption, date of absorption is defined 2.1, 36 rule 2.1.
Yes.
In case a government servant joins a corporation, 36 sub-rule 2. But this is a pension rule of 2021. Earlier rule
2021.
Yes.
Pension rules 21.
Central Civil Service Pension rule.
पुराना है. देख तो लीजिए तो क्या है. देख. Rule 36.
Rule 36.
इसको हटाइए. Keep it aside. Keep it. Don't throw it away. Keep it. But ensure that new rules are normally given. 36.
36.
Pension rule है. Pension. Yes, 36.
36, my lord. May I read again, my lord? A government servant who has been permitted to be absorbed in a service or post in or under a corporation or company wholly or substantially owned or controlled by the central government or a state government, or in or under a body controlled or financed by the central government or a state government, shall be deemed to have retired from service from the date of such absorption, my lord. But this covers my case, my lord. To understand, my lord, what is absorption, if I may take your lordship to Rule 36.2. The date of absorption shall be. In a case, a government servant joins a corporation or company or body on immediate absorption basis.
We want to, this is, your services are not governed by central rule.
Central rule.
They are governed by central rule.
Yes,
These rules
joins a corporation.
Huh?
In case a government servant joins a corporation or company or body.
No, you are an employee under which department?
Now central government, my lord. Yes.
Now you have joined the central government.
Yes, my lord. It is NLC India Limited. Public sector enterprise. The total amount of gratuity in respect of the service rendered under the sorry, my lord. In case a government servant joins a corporation or company or body on immediate absorption basis, the date on which he actually joins that corporation or company or body for this purpose, immediate absorption would mean acceptance of a technical resignation of a government servant. Now, technical resignation is defined in the notification I have annexed along with the writ petition, page 33. Later part it says appointment in a corporation or company wholly or substantially owned or controlled by the central government. So NLC India Limited is a public sector undertaking, a Navaratna company.
the case inside which is the date of your retirement or absorption.
No, they're claiming that I have not been retired. As per their definition, a resigned employee
Yes.
cannot.
Yes. You
I am saying, Malad, I am not resigned. This is technical resignation. This is Malad, completely different from the resignation in usual courts. This says Malad, deemed to be retired, deemed to have retired from service. The first paragraph of 36, Rule 36. A government servant who has been permitted to be absorbed in a service.
21 का है कि नहीं?
A government servant who has been permitted to be absorbed in a service or post in or under a corporation or company wholly or substantially owned or controlled by the central government or a state government, or in or under a body controlled or financed by the central government or a state government shall be deemed to have retired from service. Now the absorption definition is given below. Rule 36, Subrule 2. Rule 36, Subrule 2 defines what the absorption is. In a case, a government servant joins a corporation or company or body on immediate absorption basis, the date on which he actually joins that corporation or company or body. For this purpose, immediate absorption would mean acceptance of a technical resignation. So they have accepted my technical resignation of a government servant from government service to enable him to take up an appointment in a corporate or company wholly owned or controlled, substantially owned or controlled by the central government. Precisely my case, my lord. I have, through technical resignation, I obtained a NOC from the department. Thereafter, I applied. Even the offer of acceptance, my appointment letter was forwarded to the authorities of the APGCL. I have annexed along with the writ petition. And to understand, my lord, what is technical resignation, I have enclosed a memorandum of the central government dated 24 November 2022, which your lordship will find at page 33 of the writ petition.
Page
33 of the writ petition. Writ petition number 3534. Two point one defines technical resignation. May I read you? As per the Ministry of Finance OM number so-and-so dated so-and-so, the resignation is treated as a technical formality where a government servant has applied through proper channel for a post in the same or some other department and is on selection required to resign the previous post for administrative reasons. The resignation will be treated as technical resignation if these conditions are met. Well, if I apply through proper channel. Even if the government servant has not mentioned the word technical while submitting his resignation, the benefit of past service, if otherwise admissible under rules, may be given in such case. Resignation in other cases, including where competent authority has not allowed the government servant to forward the application through proper channel, will not be treated as technical resignation. To prove the fact, my lord, that I have applied through proper channel, if I may take your lordship to page 50, the writ petition.
But these are not the objection. Is it their objection that you did not apply for proper channel, therefore no technical resignation?
Not
They're
directly,
saying
but
that-
indirectly. They are saying my resignation is not technical, and that's why I will not be considered as
No,
retired.
they are saying is that resignation is not included. It is either what? Death come retirement.
Exactly, my lord.
So
This
that
rule
come
36 defines that even the employee has resigned through proper channel technical resignation, it comes under the definition of retired employee. That's where, my lord, rule 36 of the CCS pension rule, on which they are relying, the first paragraph, a government servant who has been permitted to be absorbed in a service or post in or under a corporation or company wholly or substantially owned or controlled by the central government or a state government or in or under a body control.
What is absorption?
Well, absorption is given, the definition is given, this rule 2, sub rule 2.
Yes, please read again.
In case a government servant joins a corporation or company or body on immediate absorption basis, the date on which he actually joins that corporation or company or body.
That is the date of absorption.
Yes, my lord.
What is the meaning of absorption?
Well, absorption means if I apply in the new company And supposingly, my lord, the lien is with the, my lord, parent department, with the department where I was working.
Why will you see, if you apply for a new company, you will not have a lien. Those are two separate.
But till the time I'm not permanently absorbed.
That lien applies when you are on deputation.
No, my lord, this technical resignation notification defines the notification I was relying on.
Page 33.
Yes, my lord. It defines everything, my lord.
Yes, please read again.
As per the Ministry of Finance, so and so dated, the resignation is treated as a technical formality where a government servant has applied through proper channel for a post in the same or some other department and is on selection required to resign the previous post or for administrative reasons.
So this is a term to be used in cases where you are on deputation. You are on deputation, you go somewhere. Normally, once the period is over, you come back. Therefore, you have a lien. But if you choose to be absorbed, then on the date you are absorbed, you will be deemed to have resigned. It will be deemed to be a resignation from the parent company.
Well, exactly my case. I have been allowed to.
You are not on deputation.
I'm not on deputation. I'm not claiming any lien service.
You have gone for a fresh up.
Well, this technical notification, if I may read further, well, there are other definitions too.
Yes.
Other and is on selection required to resign the previous post for administrative reasons. The resignation will be treated as technical resignation.
No. See, let us understand something. You are working in company A. You want to go and join in company B. Is there any technical reason, administrative reason preventing you from submitting your resignation in company A?
My lord,
other than your personal choice?
my lord, had it been a normal resignation, the question would have been different. Here the question is,
No, I'm asking you a very simple question.
There is no bar.
No bar. You choose not to resign, that's your personal difficulty. But if you're sent on deputation, you can't resign because you're not absorbed in that foreign company.
But I have not been sent to the other company on deputation.
Exactly.
I have applied, my lord.
You have applied
by way of a technical
by way of a fresh recruitment process in that company. In terms of deputation, you don't have to apply. There is no recruitment.
Yes.
It is only at the time of absorption you are given an option whether you'd like to go back or get absorbed. The day you are absorbed, you have to submit a resignation which becomes a technical resignation. So that whatever benefits you have there,
this will be carried forward.
Will be carried forward. This is not going to happen in your case now.
Well, my case exactly this, my lord. This technical resignation, my lord. This.
You are trying to draw an analogy of technical resignation, but this is the pure and simple case that you are working in this company. You want to apply for a new company. You have resigned. Now, whether that resignation will be treated to be sufficient to give you the gratuity under the Gratuity Act. The APDCL says no, it is not applicable where APDCL employees are covered by a different third party. Those rules do not include that. That is your key. That is your key.
Yes.
But you can't treat it to be a retirement merely because you have submitted resignation after joining the company. That term comes only when you are on deputation.
I have not submitted resignation after joining the company. I have obtained the NOC. That's what the technical resignation defines.
Why are you trying to hammer on this issue when it is not even applicable here? This is not a case of deputation.
The Lordship may allow me, Lord. With respect to permanent absorption, Lordship, I would like to rely on a judgment. Lordship, this
Let him
discuss-
complete.
Okay.
You'll get your chance. So this is the issue. It's not a case of deputation that you are transferred from here to there.
No,
That,
not exactly.
it's a case that whether you are number one entitled under payment of gratuity act. Number two, whether you are excluded merely because your entitlement under payment of gratuity act is there. You are covered. You have put in 7 years or 15 years, whatever is there. You
5 years. Yes.
You have resigned is also covered. Except that where the company, where the organization has its own set of rules, then you are not covered by this. But these rules exclude gratuity in your case.
Yeah.
That's okay. So where is the question of technical resignation and to be treated as retirement? Why can't be applied like this? When the Parent Act clearly says resignation,
Yes.
Section 4 includes
Yes, yes, yes,
resignation.
yes, ma'am.
So why
I'm-
do you have
I'm
to,
obliged.
why do you have to interpret retirement?
Yes.
Retirement or resignation? Simple.
Yes.
That's it. Yes.
On this aspect, with respect to Rule 36, pension or on absorption, but I would like to rely upon a judgment. So this is a judgment of the apex court, Lordship, Union of India versus B.R. Chadha. Lordship, page number 2, Lordship, para 4.
Yeah.
Rule 37, now, Lordship, it is Rule 36 of 2021 CCS rule. Lordship. Pension on absorption or under a corporation, company, or body, which Lordship, my learned senior read. Lordship, with respect to this rule, Lordship, the conclusion that was there in this order, para 5, a perusal of the said provision would show that a government servant absorbed in a service or post in or under a
That is exactly what I'm
corporation.
saying, para 6.
Lordship.
Para 6.
Yes, Lordship. Lordship. Two conditions, whether permission was given to him for absorption and whether Lordship his resignation was for public interest or not. Lordship. Both these conditions do not meet, Lordship. Hence, Lordship, his resignation cannot amount to retirement.
Where is that appointment letter of the subsequent case?
When letter was appointment letter, I have not perhaps enclosed here, but I have forwarded it to the authority, which your lordship will find.
Any document to show how your appointment in the subsequent company?
Yes, well, page 42. Hmm. This was addressed to the general manager by the NLC India Limited Deputy General Manager. Further to the correspondence cited under reference, we are enclosing here with the offer of appointment for the post of Executive Engineer Renewable Energy in E4 grade in NLC India Limited to be issued to Sri Abhinandan Datta, who is presently working as Deputy Manager, Civil at APGC. It is requested that the offer may kindly be served to the individual if it does not suffer any infraction at the time of serving the offer of appointment in NLCI.
While your papers were forwarded by the proper channel.
Yes.
From APDCL, was there any indication to show that you'll have to resign from the company in case of your election, etc., something like
There
that?
is no paper, there is no correspondence, but if I don't resign, that post won't be able to filled up by the authority. Well,
So
after
it must be there. If you see the references, there are a couple of letters which are referred to, 11.1, 23/6/3/23. So these letters will probably indicate how the process was carried forward.
Well, there is one document I have annexed.
Mr. Das, get these letters from the record. Let us see what is there. 11/3, 11/1/23/6/3/23.
Eleven 123 is there, page 40. This is the NOC issued.
NOC.
This is to this NOC dated 11/1/2023.
All right.
This is to certify that Assam Power Generation Company Limited has no objection to Abhinandan Datta appearing in the interview exam for the post of executive engineer at NLC against the advertisement response.
All right.
I would like to make a point.
Yeah.
The judgment that I have referred to, Lordship, in para 7, states that merely because at the time of forwarding the application of the respondent, the authorities imposed the condition that on selection he would have to resign does not mean the necessary permission has been granted for absorption of the respondent on the post
This
of
is irrelevant. This is not a case of absorption.
Lordship.
This is a case of fresh appointment.
Fresh appointment.
And this judgment is relates to claim of pro rata pension. This is not at all applicable in my case. This is not a case for payment of gratuity. This is a claim for pro rata retirement benefit.
Anything you want to submit here?
I'll have to give more instructions. We have already submitted.
More instructions are not required. You go through the provisions of this act. Do you have a copy of this act?
Lordship.
You have a copy? No.
No, Lordship, I have it on soft copy.
Yes. Take out your soft copy. This act, you go to section 4. Section 4 is very clear. Payment of gratuity on these 1, 2, 3 instances.
But with payment of
He
gratuity,
falls under
Lordship.
category B.
Lordship.
You are denying this. This is a central act.
Lordship.
So you can only exclude when there are already rules in the company defining how the gratuity is done. You have adopted some rules, but those are death come retirement gratuity. And you refuse to accept his resignation to say that he'll be covered by that. In which case, you are excluding his rights specified under the statute itself.
Well, Lordship, with respect to payment of gratuity, Lordship, we have not taken any stand.
My lord, they have submitted enough, my lord, in the payment of gratuity act. The learned senior, my lord, appearing on the other
Lordship,
day.
that was with respect to
And
submitting the
well,
affidavit.
that
in
day, your
opposition
lordship
that
indicated that
we
the
have
matter
kept
is
it open.
disposed of. And the next matter, my lord, leave encashment, they have invoked one rule, my lord, 39(6)(1). I am saying I come under 39D. Well, this is the only issue. They have quoted wrong provision.
Next matter is connected matter.
Connect leave encashment, the same person.
Leave encashment we have given as per our office order, Lord. Since he has resigned from service.
My lord, the resignation, my lord, I have explained there how, my lord, the resignation will come in the case. So far as gratuity is concerned, my lord, the other day, my lord, learned senior has submitted, my lord, enough on the case.
Is there anything to submit?
Also with gratuity, we don't know. We don't want to submit anything.
Take down. Learned counsel for the parties. This writ petition is filed by the writ petitioner who at the relevant point in time was employed under the Assam Power Generation Corporation Limited. As a deputy manager civil. So he was appointed in his service. When were you appointed?
Well, I was appointed in the year 2015.
Appointed in his service in 2015 and had been continuing in his service. So subsequently, in response to an advertisement, dated advertisement number 07/2022. Which company you have joined?
Well, NLC India Limited.
NLC, is it a corporation?
It's a public sector enterprise.
NLC India Limited. He applied for and was subsequently selected and appointed as what?
My lord, as
Executive
page 40,
is an executive engineer.
exact, my lord, Deputy General Manager
Deputy General Manager.
/ MPP and
No,
recruitment.
no, not deputy.
Yes, my lord.
You come to para number 5.
For the post.
You had
My
applied
lord,
for
executive engineer, sorry.
executive engineer.
Executive.
Stop. He submitted the necessary documents through, he applied for the said post through proper channel, and an NOC to that effect was issued by the APGCL. Stop. Subsequently, he was successfully selected and appointed to the post of executive engineer civil. Thereafter, the petitioner resigned from the parent company, namely the APGCL.
APGCL.
Filed necessary application, praying for his service benefits, including gratuity. So, his application was taken up by the appropriate authority in the APGCL and by in its 91st meeting held on 29/7/2021 by the resolution number 19 adopted. An office order was issued. His claim for gratuity stood rejected the ground that he is not covered for the extending the benefit of death retirement gratuity to the employees of APGCL covered under the National Pension System in terms of office order dated 17/8/2021. The petitioner represented before the authorities concerned, however, his representation were. Did you file any representation?
Yes, my lord.
Rejected?
Yes, my lord, not yet, my lord. They have forwarded to the higher authority. Till today, no decision is taken.
Which remain pending. And accordingly, the petitioner has approached his court, praying for appropriate direction. The respondent, the learned counsel for the petitioner submits that under the Payment of Gratuity Act, the petitioner is entitled for payment of gratuity, and his rights under the statute cannot be denied. So it is further submitted that the respondents have rejected the claim by wrong interpretation of the office order dated so and so to come to a conclusion that death cum retirement gratuity payable to the employees of APGCL will not include the case of the petitioner, as he support of his complainant, he refers to judgment of, you are referring to which judgment?
Well, I have not submitted any judgment.
You have not. The respondent on the other end contested judgment as reported. The judgment, if the respondent have contested the claim of the petitioner by filing the necessary affidavit, and the claim projected by respondent, the objection of the respondent that the APGCL has adopted the government of Assam policy which is reflected in the order dated 17/8/2021 for extension of the benefit of death cum retirement gratuity to the employees of APGCL covered by NPS on the same terms and conditions as are applicable to the employees of the CPS pension pool. Sorry, this policy is the government of India or Assam?
No, pardon me.
Death cum retirement gratuity benefit.
Well, it is CCS pension rule 2022.
According to the respondents, the board had considered and approved for the grant of DCRG benefits to the employees of the APCL who have joined the APCL and comes under NPS, keeping in view the benefits of DCRG provided by the Office Memorandum number PT so and so dated 1/2021. The NPS employees of the government of Assam, page number 41. According to the respondents, the claim of the petitioner that he is covered under the provisions of Section 4 of the Payment of Gratuity Act is not, it is disputed in as much as it is submitted that the provisions of the Payment of Gratuity Act are not applicable where the organization has its own set of rules granting certain benefits. So, it is submitted that since the APGCL board has already adopted the payment of DCR in terms of the board resolution dated 29/7/2021. The claim of the petitioner that his payment will have to be the claim of the petitioner for grant of gratuity under the Act will therefore be governed by the policy and the principle adopted by the APGCA. The respondents have relied upon the judgment of Madras High Court and two judgments of Madras High Court and in support of their contention. So, in rejoinder, the counsel for the petitioner submits and the gist of the objections raised by the respondent that if the petitioner has signed the TCR benefit will not be as for its benefits are paid only on death retirement. So, on retirement PM, in the time present case, petitioner did not retire from the PCL but has resigned in order to join new employer. Therefore, under the policy. Rejoinder counsel for the by referring to 36 of the CPS part that the resignation which the petitioner had submitted is a technical resignation and in view of his absorption in the new employment and therefore it has to be treated and the date of absorption in the new employment will be the date he has submitted his technical. He submits that the 36th of from the date of his absorption in new employment, the title pension certificate. And therefore, the resignation which the petitioner has submitted has to be treated technical resignation covered under 36 and therefore claim to be rejected by this one. That's it? Yes. Counsel for the parties of heard. Just payment. At the outset, under section employee is defined as under section F, employer is also defined as the applicability of the benefit act prescribed under section 4. Under section 4 is extract or any a reading of the above provisions of the act clearly indicates that the petitioner, the respondents are employer included in the definition prescribed under the act. So is the employee, maybe the whose services will be covered by the definition. Insofar as the benefit under section 4 is concerned, they shall be available any employee on termination of his employment after he has rendered continuous service for not less than 5 years on 3 situations or circumstances, namely on his superannuation, on his retirement or resignation, end of leave, or on his death or disablement due to accidental disease. Stop. Therefore, perusal of section 4 above clearly reveals that resignation is also included to be considered in case of an employee at the time of grant of payment of gratuity. Stop. The only requirement is that there must be continuous service of not less than 5 years. In the case of the petitioner, he had rendered continuous service for
7 years, my lord.
7 years.
7 years.
7 years.
7 years, 6 months.
7 years, 6 months, and which is not disputed on fact by the respondent. Under such circumstances, it has to be held that under the provisions of the Payment of Gratuity Act, the petitioner is entitled to be considered for payment of gratuity as he fulfills parameters prescribed under section 4. Stop. The only rider is that the provisions of this act will not be applicable where a particular employer has its own set of rules which will govern the payment of gratuity. Stop. In the present case, the respondents have declined to consider his claim for gratuity on the ground that the board has in its position a set of a decision for grant of death cum retirement gratuity, which was adopted by the board in its 91st meeting held on 28. And since this gratuity is to be paid on either on death or retirement of an employee governed under the NPS, National Pension System, the case of the petitioner cannot be considered as he had resigned, as he has submitted his resignation pursuant to his appointment in a separate public sector undertaking. Stop. I think noted the factual and the legal position question cited by the court with the rights available for when employee under payment act can be deprived of or curtailed by an employer. The detriment of the employer. There is no dispute that the provisions of payment of gratuity act the mandate of the Central Bank of payment of rent will apply to another member. Section 4 create a mandate payment of rent. Pensioner admittedly is covered under Paragraph 7 of the even assuming that the employer has adopted a policy and that it only the employee who either die in harness or retired / superannuated officer the company from a question is being made whether the benefit available to an employee under the Act of 97 can be deprived of by the employer, maybe the responsible. The policy, the rule stated to be adopted by the company for transport gratuity clearly excludes the retention as it uses to accept that it is applicable also to employees who can select on a point very made by the court with respect to specific answer. The respondent have respondent submit that once policy is adopted by the respondent and which policy is not under valid and the policy is framed for payment of gratuity to its employees due to death or accident. The provisions of section 4 provisions of the Gratuity Act of 1997 not be applicable as the petitioner does not have cannot have any claim under the other act. So, such submission clearly bear paper of the specific requirement of the specific declaration of the Section 4 Act is for payment of debt. The employees who are covered under the by the employer covered under the Act. As has been discussed above, the petitioner calls the examination of it, as well as the as also the respondent falls under examination of M. And accordingly, this court is of the view that the mandate of Act of that it have to be cannot be taken away. The benefit of gratuity is conferred under the mandate of Act of 7 cannot be taken away by the respondent. Right? Able to the interpretation of thought to be projected before the court by that the resignation in effect, the terminal resignation submitted by the state. However, cannot be accepted as the petitioner was never sent for the application for new corporation in the NCL. So, it is a fresh appointment which the petitioner applied for while he was the property. So, nevertheless, where the act with its clearly provides for availability of grant, availability of payment to the employee who may have resigned or retired after completion of 5 years of service. So, the authorities cannot break a rule which will exclude the claims of the with respect. Under such circumstances, the court considers it appropriate to issue a direction on consider the claim of the petitioner for grant of the act with effect of the date it is applicable and forthwith take all steps for the release of the state. Because the court submitted at the bar and the representation filed by the petitioner. Where is your representation?
Well, representation page 51.
It has already been filed by the petitioner before the authority concerned and stated to be pending. In fact,
Page 51, page 44.
accordingly, the respondent will pass necessary orders to grant of gratuity to the petitioner under the provisions of the Payment of Gratuity Act and release all service benefits the gratuity as not paid to the petitioner from the entire exercise we carried out in the period of
1 month, madam.
1 month.
30 days from the date of the petition. The petition will be paid out before the likelihood in view of the petition arrived by the court, the judgment pressed in service by the respondents do not support the case of petitioner and therefore does not require allow.
Much obliged.
What about the other matter?
The other matter, they have
Lordship, with respect to the leave
Other matter,
encashment,
we'll take it up next week.
Yes,
after one.
But the judgment that I have placed, Lordship, will rely upon that. VR that Lordship.
Whatever you want to place in the other matter.
Lordship, we have already placed in.
This is item number?
We have 7, Lordship.
6 and 7.
7, Lord.
Item 7.
6 has been disposed of 7.
Item 6 is disposed of, 7 to be listed separately after 1 week.
Much obliged.